Well, welcome, everyone, and welcome to Thursday Night Law Extravaganza, which we have renamed because some people thought bar review was a little unclear. And I appreciate that because some people either thought we'd be doing literal reviews of bars, which also, by the way, sounds like fun for us to potentially do, or potentially it was a stream dedicated, reviewing the bar, which also sounds like fun, but not in the spirit of what we were trying to do. We're just trying to do a fun stream on Thursday nights, sort of in the style of what Rob does on Fridays, sort of in the style of what Ian does on Mondays, just to fill another day of the week with law knowledge so you will not go a day without some fun and frivolities. And Thursdays sounded like fun to me. So welcome to Thursday Night Law Extravaganza. I hope everyone is having a great day. As I'm sure many of you noticed, on Wednesday, we did a more edited video in a long form that was just voiceover with text, with B-roll. And I hope, by the way, that some of you have seen it and you like it. We're going to try experimenting with that kind of thing for the next month or so, and then perhaps reevaluate. So we've put some money behind things because up until this point, I've been doing my own editing and I've been doing my own recording. And so the cost to running the channel has been basically, well, at least for the major production stuff, has been free, although there's a lot of stuff behind the scenes that costs money. So the actual expenditures of this channel have been several $100s every month. I'd have to actually check, but I think typically it's like $600 or $800 to run the channel in sort of just various things I try to do to make the channel work. From the video software that I'm using right now, for example, that costs money. For various licenses for things I have that cost money. So your financial contributions are important. But hey, we decided to actually put quite a bit of money behind editing this month to see how that works. And if it really takes off and winds up being revenue positive, then we'll keep doing it. And that will be good. So we'll see how it all goes. So check that out and see how it goes. Tomorrow, hopefully, I'll have a video about the Israel war. So a little bit late to the game, I suppose, in sort of things, because everyone else has had their hot takes, but that's the video I have planned for tomorrow. It's an interesting video because I originally recorded it with a lot of background information, because I was so worried that people were going to worry about, like, you don't know anything. I'm like, okay, so let me step through exactly how we got here. By my count, this is the 7th major conflict that Israel has had since becoming a nation state. Let me lay out for you what those 7 conflicts were, and sort of went through like the entire history and how we got here, basically trying to summarize the last, 70 years or so. And, but it wound up being too much. So I wound up trashing kind of all the background data to just get to the immediate incident, and still wound up being 14 minutes or something. So hopefully people will like it. Or it might have been longer than that, actually. I'd have to see how much it wound up to be. Because trying to give an accurate history of this in any sort of approachable bite was challenging, to say the least. But hopefully you'll like what I came up with tomorrow, and we'll see. So that hopefully will post tomorrow about 1 p.m., depending on whether or not my editors get it done in time. But that's where we are in terms of that. So hopefully you like all those things. So yeah, trying to go through, let me step through a brief history of how we got here. Israel and you, a brief crash course. Oh Lord. Yeah. I did pretty well, but the video would have been like another 7 minutes long with the information, because I'm like, let me step through every conflict that Israel's gone through in the last 70 years. Here's 7 major conflicts. This is the 7th major conflict, the way I chose to count them, which is somewhat arbitrary, I admit, but that's what I went with. And I had to trash like 7 minutes where I'm like, let me give you a brief history of every major conflict that Israel has been involved in. So anyways, yeah. All right. So that is enough background information and enough about what's going on in sort of programming notes. I hope that you will catch some of that and you will like it, and it will be good for the channel. So we begin this evening with our friend and yours, Mr. Alec Baldwin, who it appears will once again face charges for involuntary manslaughter in New Mexico for the Rust movie shooting. So the prosecutors in the previous iteration of this somewhat embarrassed themselves at various stages of the prosecution. They kind of screwed it up a couple different ways. And there were some problems. And so the prosecution probably made the right decision in retrospect with, trying to like go back to ground, right? Let's go back to zero and try again. Because, there's no double jeopardy because we haven't gone to the jury yet, right? So this case is not so far along that we can't give it another shot. So, to use the pun. And we're going to do that. So it looks like Alec Baldwin will once again be charged in the Rust movie shooting, and hopefully they won't screw it up so badly this time. Hopefully having learned from their prior mistakes. So we'll see how that goes. All right. Special prosecutors, because the main prosecutor screwed it up so hard they recused themselves. And then they appointed a different special prosecutor, which was unable to do the job because they were also, at the time, a legislature. And New Mexico's constitution forbids you from being both a member of the executive branch, which a prosecutor is, and the legislative branch at the same time. Incidentally, it's also a violation of the US Constitution. So it's not particularly surprising it's a violation of New Mexico's constitution. Because you can't be in both the legislative and executive branch at the same time, right? So it's like, okay, I'm a legislature and the special prosecutor. No, you're not. No, you're not. So that was a whole thing, right? So having, found someone else, hopefully, who will not be so conflicted out, we have a new special prosecutor who said they're going to try again by starting over with the grand jury. We're going to go all the way back to ground and redo this thing. We'll do take two, kind of like Rust itself, where we redid the entire movie, right? We scrapped all of our earlier footage and we refilmed the whole thing. So as Rust has had a complete do-over, so too will the Rust-related shooting. So I suppose there's some parallels there for you. Anyways, they're going to try to press this charge for the fatal shooting. Baldwin, of course, was an actor and somewhat notably also a producer on the movie, which potentially exposes him to further legal liability. Not that we really needed it in this particular instance. That's more of a civil liability issue than a criminal liability issue, but still, it definitely disallows him to some degree from moving the ball. Because it's like he as he tries to hand the ball off to someone else and be like, it's really someone else's responsibility. The fact that he is the producer kind of somewhat undercuts some of those arguments. So there is increased civil exposure and perhaps some twists that in the criminal law case as well. Of course, the movie at the time was being filmed in Santa Fe. As an actor, he was holding the gun that, discharged during rehearsal. Baldwin pointed the Colt 45, which was not supposed to have been loaded, directly at the camera, and then the bullet went off and killed the cinematographer and wounded the director. Yeah, that definitely happened. And then, he tried to absolve himself of responsibility because, of course, he did. Baldwin has long maintained he shouldn't be held responsible for the shooting, which, I think there's some arguments that are potentially viable. And I think even he could potentially win at trial, depending on the arguments and depending on what the jury thinks and sort of like who's responsible here, right? If he makes the argument that, I think probably his best practical line of argument is just to basically be like, I reasonably relied on the armorer to do that, as I've reasonably relied on so many armorers, as my entire industry relies on the armorers, and I took them at their word that the gun was in safe condition. So although handling a firearm normally would imply the duty to handle it as a reckless instrument, an instrument inherently capable of harm, rather, because the instrument itself is inherently capable of harm, normally picking up a firearm implies a greater duty on you. The duty is inherent because the article you're handling is dangerous inherently. But he might be able to get around that idea with the idea that he reasonably relied on a professional who had assured him, as so many other professionals presumably had, that the firearm was in safe condition to be handled. And so he, made the decision there as well. So that's potentially, I think, the best practical line of argument. And we'll see how it goes if it ever winds up for a jury, because we have a long way to go between here and there. He told authorities and reporters that he remembered pulling back the hammer of the gun, but not actually the trigger itself. 5 months ago, of course, special prosecutors dropped the involuntary manslaughter charges, saying they were informed the gun might have been modified before shooting and malfunctioning, but that was just the latest in a comedy of errors, really, and it was just one thing too many. So it wasn't really the gun might have been modified. That was just the latest of many problems. So, yeah. But they left open the possibility of refiling, as they should. Prosecutors reportedly have received some sort of new analysis of the gun, which I don't know what that is, but sure. Fine. They somehow received some sort of magical new report that somehow clarifies the issue. I don't know exactly how that was supposed to have happened, but apparently. The prosecutors have been quoted as saying, after an extensive investigation over the past several months, additional facts have come to light that we believe show Mr. Baldwin has criminal culpability in the death of Helena Hutchins and shooting of Joel Souza. We believe the appropriate course of action is to permit the panel of the New Mexico citizens to determine whether Baldwin should be held over for criminal trial. So one of the things they can do is bring in all this evidence into the grand jury, and therefore the grand jury will have more they won't be able to argue as much. The grand jury was blindsided. So they'll presumably bring more into the grand jury than they would in a typical case. It's sort of exculpatory evidence, but they probably will do it in order to try to save themselves some problems down the road. So we'll see what the grand jury, of course, does. It's a long way to go. Dash Justice says, if you're holding the gun that kills someone, you have to be guilty of someone. You don't have to be guilty of something, but the fact that you're holding the gun when it goes off is certainly not a strong indicator in your favor. The police and others are going to have questions. These questions will be uncomfortable. So you don't have to be guilty of something, but it's not an auspicious start, to be sure. Baldwin's attorneys responded to the news in their own statement saying it's unfortunate the terrible tragedy has been turned into this misguided prosecution. We will answer any charges in court. Meanwhile, the film's armorer, Hannah Gutierrez-Reed, is set to go to trial in February, having pled guilty to involuntary manslaughter and evidence tampering in the case. Unclear, incidentally, why these uncertainties revolving their gun didn't impact Miss Gutierrez's case, but impact Mr. Baldwin's case, although his case was arguably more poached than hers. But I digress. Last spring, the film director and safety coordinator David Halls pled no contest to unsafe handling of firearm and received a suspended sentence. The legal saga, of course, at this point has continued for several years. Among other twists and turns, the initial special prosecutor, who was a legislator, and the district attorney, who fouled it up in other ways, both resigned. Yeah, it wasn't going over great. The cinematographer's widow has dropped the wrongful death lawsuit against Baldwin. As part of an agreement, he was made executive producer of Rust. The film's remaining scenes wrapped up in Montana in May. So they didn't want to film again in New Mexico, I guess, deciding that they didn't want to tempt fate, perhaps, or perhaps that New Mexico had lost some of that enchanted charm that New Mexico is apparently so famous for. I guess they felt it was less enchanted on the back end than they did on the front end. So that is something to follow as the case continues, and we will see how it all progresses for sure. Thank you all very much for joining me tonight for this Thursday night law extravaganza. I appreciate that you are taking the time to spend some time with me. I appreciate every one of you who is part of the Uncivil Law family, and I appreciate every one of you who is helping me, first of all, financially, for starters, because the money helps because I can then afford things like editors, or at least take a chance on something like editing that will help. So I really appreciate the financial support, and you now see at least part of where that's going. As I say, there's a lot of behind the scenes costs that aren't necessarily obvious from various services that I use to try to make things a little better, like the audio enhancement, for example. Spend money there to make the audio better for my videos. Spend money on this broadcasting software. There's a monthly fee for that. And just various other things that incur cost. So It's not free necessarily to run the channel, and I do appreciate everyone who helps. It really makes a huge difference. And also helps with my cheerier disposition in general. I had a nice day at the gym, by the way, today. I'm happy to say I've been going every other day pretty routinely, and today was one of my on days. I made the decision recently to try to alter my workout a little bit by switching between lower body and upper body, because I had been doing full body workouts every time, but I thought, maybe giving my muscles a little bit more chance to breathe and relax and repair, I switched. So today was an arm day. Today was upper body day, and I had a good workout doing upper body. So that was really good for sure. All right. I want to talk a little bit about this whole Isim trademark thing. Nick Rekieta, as I'm sure many of you know, has been covering this story about Isim versus Isim. And the whole thing is a little weird and a little bizarre and a little petty on the part of the Isim ministries, in my view. But I thought we could cover some of this development for those of you who don't know what's going on. So first of all, we have two parties in this dispute. We have Good Shepherd's Ministries, which runs an international church, which goes by the acronym Isim, and Eric July, who has a comic book that has a hero called Isim, okay? So on the one hand, you have the international something ministry, Isim, and on the other hand, you have the comic book character, Isim. I'm not sure how a person would confuse these two things, but Good Shepherd Ministry thinks these things are worthy of confusion. So I don't know. They're going along those ways. So, anyways, Good Shepherd's Ministries is suing Eric July and what is known as the RIPA universe over the Isim trademark, accusing the organization. And then Eric July, of course, responds by saying that they're just trying to shake him down. So it's okay. It's a thing. All right. Eric July has issued a response to Good Shepherd's Ministries after Good Shepherd's Ministries declared he'd be proceeding with suing July and his comic book company Ripaverse over a trademark dispute concerning July's Isim character. In response, July accused Good Shepherd's Ministry of attempting to shake him down. Okay, so here is the character Isim. He is a black superhero, and he's got a cross on his crotch. So he's a Christian superhero, I suppose, and is showing you the love of God from his nether regions, I guess. So that is Isim, the comic book character. Okay, and all of his Isim related glory. The Good Shepherd's Ministry outlined in a lengthy post that they would proceed with a lawsuit, claiming that July was infringing on their trademark for the word Isim as relates to ministries, the M in Isim standing for ministry. So, yeah, they say that your comic book character, which is Christian, will be confused for our church. Okay. So Good Shepherd Ministries states the core issue at the trade dispute is trademark infringement. That sounds right. The basic test for trademark infringement is whether consumers are likely to be confused as the source of trademark things. In other words, to believe there is a likelihood of connection. That is definitely the principal way of looking at trademark law. Consumer confusion. Consumer confusion. The consumer believing the one thing is in fact the other thing, or believing they're related, or believing they're tied, or believing other things, right? So the consumer confusion is sort of the dominant test. There's a couple different ways of looking at it, and sort of how we look at how the consumer is confused and what way are they confused? Are they confused by believing this product is the other product? So you could imagine that, for example, if you went into, for example, a convenience store, right? You went into a convenience store and you want to buy a soda and you see a red can with a swirly white mark and, some scripted letters on it, and you buy it believing that it is Coca-Cola, but it's not Coca-Cola, right? It's some other thing, right? But you bought it believing it to be Coca-Cola because of the red can and the white and the scripting and yada, yada, yada. So that'd be one way of confusing. Another way of confusing would be because you believe those are tied. That would be the Jack Daniels one. For example, you don't necessarily believe the squishy dog toy is produced by Jack Daniels, although you might, but you think it's authorized by Jack Daniels. It's something that Jack Daniels is partnered with. And so the reputation of one might lead on to the other. And there's a couple other ways of looking at it, but consumer confusion is what you're looking for. The consumer is in one sense or another confused about the origin of the goods. Where's this thing coming from? What's its affiliation? What the hell is it doing on my shelf? What is this thing? Great. So that's right. So they think consumers are likely to be confused because of Good Shepherd's decades of using its Isim trademark, which sure, I'll give you that Good Shepherd's has used Isim as a mark for decades. I'll give you the point. And Mr. July and his company started using it a little over a year ago as part of the name of a graphic series novel. I mean, that's factually true. It's just, is the one confused for the other? So yes, it's true that Good Shepherd has used Isim for decades. It's true that Mr. July has used Isim for his comic book character over the last year. So those facts are certainly true enough. The question is the consumer confused? And they say for their part, we're already far past the point of likelihood of confusion. We have evidence that Mr. July and his company have caused actual confusion, although that evidence, at least in this lawyer's humble opinion, is a little bit, shaky at best. And also might be trolls, to be quite honest, right? There are people who actually do know what's going on, but they pretend like they don't know what's going on because they want to burn Mr. July and or see a fight and or whatever. So there is some evidence of some people potentially being confused, although I'm not convinced the evidence is in fact real, but perhaps it's another issue for another time. So yeah. So in response to the statement for his part, July issued his own statement and describing the lawsuit as baseless. And I have to say this, okay? With all due respect to Mr. July, all right, I've listened to him, at least in part, not for the least of reasons that I listened to him on Nick Rekieta's show. And I have to say this. Mr. July at this point, by opening his mouth, like so many people, is his own worst enemy. All right? I think in the naked abstract, right, I don't really think there's much of a consumer confusion. I don't think there's really much of a problem, right? So when I went on Nick Rekieta's show and discussed this, whatever it is at this point, 2 weeks ago or whatever it is at this point, it feels like 2 weeks, something in that frame. Anyways, when I went on and discussed this 2 weeks ago or whatever it is at this point, I basically poo-pooed the lawsuit. And I'm like, I don't really see this. This isn't going to work. I don't think there's a problem. There's no confusion. Now, all those conclusions were accurate at the time. But then, of course, what happened? Mr. July opened his mouth. And you know how that usually goes. And it went that well. I mean, it's not the worst I've ever seen, but he has certainly not enhanced his side of the equation. So if Mr. July winds up losing this case at this point, I think him opening his big mouth may be a large part of why. Which is one of the reasons that lawyers incidentally tell you to keep your damn mouth shut, because your odds of opening something and saying something that are going to be detrimental to you are pretty high. So, yeah, Mr. July opened his mouth and he said a whole bunch of things. And the things are not necessarily painting Mr. July necessarily in the best light, in my humble estimation, making Mr. July seem potentially somewhat unhinged and somewhat questionable as a participant in this equation. And those elements could be used to potentially cause his case to somewhat be impacted in negative ways. So, Mr. July is at this point, at least with respect to his own case, his own worst enemy, I think, in large part. July went on to say, in part, we are not in any communication with Good Shepherd or the International School of Ministry, which is what Isim stood for. I couldn't remember, but there you go. International School of Ministry. So that's what it means. Okay, great. We're not in communication with Good Shepherd or the International School of Ministry prior to filing of the lawsuit. There were no obvious opportunities presented to engage in good faith conversation before the lawsuit was filed about what's being alleged. Not that they necessarily have to, of course. There's no obligation to do that. You can just, sue somebody. And then you can be like, let's negotiate, or you can negotiate up front or whatever. So, and they want to file first to perhaps put some pressure on, but fine. We're not made aware of any of Isim's International School of Ministry had any issues with the RIPA universe until the lawsuit was filed. Not only did it make the ordeal public, but it was news to us. Well, that sometimes happens. Sometimes your first clue there's a problem is the lawsuit, is the process server knocking at your door. Not always, of course. That's not always the first sign, but it's not exactly unheard of. He then added, so if anyone alleges that Good Shepherd just wanted to get clarification, we find filing a lawsuit is an interesting way to go about it. It isn't the worst way to go about it, to be quite honest. You want to put some heat on them to like get their attention, potentially, and let them also know you're serious and also preserve your rights and everything else. So, okay. Despite all this, we have no problems entering into a good faith discussion with the International School of Ministry. Okay. So they would like to potentially resolve this, which I don't know what that would look like, to be quite honest, in this case. And here we again see Isim, again, with a cross right on his crotch. Apparently, that's the Christian way. I suppose. I don't know. I'm not sure about this aesthetic design, but okay. It's their comic book hero, so all right. If the main issue was centered around assuring there was a distinction between RIPA and the International School of Ministry, we'd be open to negotiation. We disagree that anyone would truly confuse the ministry and a comic book company or a comic book character, but we're certainly open to hearing and addressing real concerns. I tend to agree with Mr. July on this aspect. I also tend to agree that I don't think the consumer would be confused. And this isn't a least common denominator test. All right. This is not who is the stupidest person in the room. All right. The fact that you can point to someone somewhere being confused is not enough. Right. We talk about the reasonable man test. And as always, the reasonable man test comes to the rescue. Right. The reasonable man test is great. It does so much good work for everybody. Right. So we don't have to least common denominator this shit. So the question is, with the reasonably prudent person, the ordinary man, the man off the street, is not particularly well informed. He's not particularly well educated, but he's not a dunce either. But he might not necessarily be paying incredible attention. So, if he goes into the convenience store and he picks up a can that's red with a white stripe and it has some white, lettering, believing it to be Coca-Cola, if he had spent half a second looking at the can, he would have maybe be able to determine that it's not Coca-Cola. But that's okay. We don't require him to do that, right? The fact that he made, the snap decision because he recognizes those shapes and colors and scripting. And he says, aha, I know that that's Coca-Cola, so I don't have to investigate that fact either further. The fact that he came to a snap decision is fine because it's a snap decision that was informed by reasonable experience of the reasonably prudent person, right? So it doesn't require any particular, exploration or any particular detective work. But the question is, would the reasonably prudent person think these two things are related? I tend to think no. I don't think that, Isim the church and Isim the comic book strike me as particularly related things. But, that's what I think. But, maybe someone else would disagree with me. And the way that Mr. July opens his mouth, it doesn't certainly help with that end conclusion, to be quite honest. Mr. July continuing, we've had some settlement discussions. And though we were on track to find a mutually beneficial solution, we were blindsided when they demanded profit from our company to be part of the negotiation. Yeah, that would be what we call unjust enrichment. That's what they think, right? They think that you have unjustly enriched yourself using your name. So you're not entitled to that money because that money was earned dishonestly. So they're suing you for unjust enrichment. It's like the money you got in profit, we'd like that very much because you earned it off our back. If you make a product, with a can, with a red can with the white stripe and the white curly lines and blah, 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 Coca-Cola gonna want to get paid, yo. So, yeah. That's going on. And they want this to be perpetual, which, that makes sense. It's a licensing fee. So, yeah. Again, this is shocking. The demand for profits doesn't seem to have much to do with alleged concerns over confusion. Well, maybe they're willing to license it to you as part of the settlement. So they're willing to absorb some of the confusion for cash. So like one, stop doing it. Two, if you don't want to stop doing it, then we're willing to absorb it for cash. So they could just seek straight injunctive relief, right? They could just say, stop it, period, end of discussion. But if they want to say that we're willing to strike some sort of license with you, then that's an acceptable thing too. So, okay. I mean, that kind of makes sense. Apparently, they continue opening their mouth saying, but even worse was the International School Ministry is demanding limits on our ability to create, and that's all we want to do as a company, build characters and create comic books. Yeah, they do want the ability to limit your ability to create because your ability to create interferes with their rights, okay? They have a particular thing that they have established, and they would really prefer that you not do that. For example, the name Uncivil Law. I'd like to take notes that, it's like if some creator out there is just using my name, I'm going to be a little salty about it, because I've taken some time to try to establish this, and as a mark. And yeah. So we want to give our customers a good time and we want them to have fun. In the words of Neil Gaiman, we strive to make good art. No one is opposed to your art except, maybe for artistic reasons, but we do have an objection to what you're calling it in the nature of the trademark. But yeah. Mr. July went on to say that his character of Isim is apparently named after one of his family members, which I'm not sure I necessarily believe that, to be honest, that it was in fact named after one of his family members. He says the name Isim is the first name of the second generation patriarch of his family, Isim Knox. He's born 1851 in Arkansas and is his great-great-great-grandfather. I am doubtful that that is in fact why he gave it that name. I don't know why, but I just find that a little bit difficult to believe. Why would it be the first name of the second generation of his patriarch? Why would that particular person, and why did he choose that particular one? And, is Isim Knox someone that is talked about in his family with reverent tones or somebody? Is he someone that has particular clout in the family? So I have some doubts in my mind that he was in fact named after this person. So, okay. Did he desperately look for his family tree to see if he had anyone named Isim after the fact? I have some doubts, to be honest. Next, July detailed that the surname Silman is his great-great-great-grandmother's maiden name, her name being Mary Jane Silman. As for Avery, July revealed it's based on his great-grandfather, Avery Knox, who was born in 1897 and is Isim's grandson. I don't know. I don't find that story particularly credible. Maybe it's just me, but it seems a little convenient somehow. I don't know. Maybe it's just me. We scrolled through the entire family tree. Yeah, sure. It was, my 18th cousin, third removed, really important to the family. Sure it was. So I have some doubts there. He then detailed, so this character's first, last, and hero name are all based on real people that are my family members. The name Isim predates Good Shepherd in both my family and many other instances, which incidentally, by the way, isn't necessarily a get out of jail free card when it comes to trademark, because I'd like to point out the obvious that quite a lot of trademarks are just someone's name. McDonald's comes to mind as an example, or McAfee antivirus, or Dell computers, or Gold's Gym, or, yeah. So, if someone establishes that mark and it's their name, well, yeah. In fact, for those of you who might not know the story, it's, I think, at least a little bit interesting. Mr. Gold of Gold's Gym, of course, sold his gym. He sold it at one point, and then he kind of felt bad about it, and then he started a new gym, and he couldn't call it Gold's Gym anymore. And I'd have to look up what he called it because I forget that part of the history. but let me look it up real fast because it had a kind of a lame name. Yeah, so Joel Gold finds Gold Gym. World Gym was the name of his following gym, which obviously didn't have the same success as Gold's Gym. So yeah, he had the name Gold, and he couldn't call his new gym Gold anymore because because there was already a gym called Gold, and he couldn't use the same name again. So yeah, the fact that it is in fact his name. First of all, I'm not sure I believe your story. Second of all, even if I did, that isn't necessarily a get out jail free card. You can in fact restrict someone from using their own name in trade, as Haley Page Gutman learned as we discussed that lawsuit from a while back. Remember when Haley Page sold her name? It's like, yeah, you don't get to use your name anymore, but it's my name. It sure was. But then you sold it like an idiot, and it's not your name anymore. Now it's some company's name, and they get to use it forever and ever and ever. Very exciting. Yeah. Andy Rance says, my initials are ATB. Would I get sued if I use it as a limit name by someone with 2B? See, it depends on a whole bunch of things. Trademarks are based on what your trade is. So it depends on what you do. For example, Apple, I suppose, is less a good example at this point, but there was a time and a place when no one would confuse Apple Music with Apple Computers. Apple Music, as I'm sure some of you may remember, was the company that was behind the Beatles. This is long before they got absorbed by Apple Computers. And there was a time and a place when no one would confuse Apple Music with Apple Computers. And then, of course, that became less true. And then Apple Computers eventually wound up buying Apple Music to solve the problem. But yeah, a trademark is typically only in a respective business or a respective area. So as long as you're in a different kind of business, there's typically no problem. It's not like anyone, although McDonald's is a famous mark, so that example wouldn't work for McDonald's, but it probably would work for something like Dell. Dell's not a famous mark within the sense of the law. So if you had some other kind of business that wasn't computers or couldn't be confused for business and you called it Dell, that would be fine, right? Trademarks only apply within their own domain. They are not universal marks, unless your mark becomes so big that it crosses all boundaries, but those are fairly far and few between. Coca-Cola is that way. McDonald's is that way. There's not many marks that go that famous. It's kind of hard to pull that trigger. So yeah, you can use the same name just as long as you're not in the same business, as a broad rule. Anyways, July went on to reveal that the International Church Ministry over there said the sad situation is that Dr. Gilfriend, Good Shepherd's founder, personally asked me this when we met, and I did. This was before they demanded a perpetual profit off our work, a profit off my enter to family. Okay, I don't know what that has to do with anything, but fine. They added they're unwilling to withdraw any monetary payments and do not take these frivolous threats lightly. Well, they were frivolous, at least at one point. Well, frivolous is a strong word. I don't know if I go so far as to call it frivolous. Frivolous is one of those words that we try to avoid, because calling someone's claim frivolous is pretty insulting to a lawyer. So I don't know if I'd call it frivolous, I especially because he keeps opening his mouth, and that's not helping. Moving on to the claim about trademark, July said, now a trademark is connected to a specific good sold under the mark. It sure is. A class of goods is more a better way of thinking about it rather than a good, but a class of goods. Good Shepherd failed to accurately compare the relevant goods. That's the right level. That's the right argument. The goods identified in registration fall into distinct classes. See, so these are trademark classes. This is how one of the ways the trademark office thinks about it. Class 9 covers audio materials and class 16 covers print materials. In the original letter to me, class 9 is what they rely on, but that's limited to audio material, not comic books. So there's some misidentification of the covered goods in the lawsuit. That's obviously a problem. It might be a problem. It depends in which marks the thing is registered. Although the trademarks office's classification is not necessarily the end all be all, but it is a solid place to start. But they're trying to expand the scope of the goods they claim under the mark by claiming they are printing instructional, educational and teaching materials in the field of religion, which is direct text from a registration, somehow could be confused with comic books. Yeah. But the worst part is the ministry claimed goods involve religious content, not comic book characters. I don't know about that line of argument, but okay. Conveniently for them, the argument broadens the scope that they've claimed with the trademark office. Yeah, and so here we have some more art from Isim. So, okay. July says, we don't sell audio or electronic books. We do not sell print material centered around religious or instructional content. Our industry is dominated by physical copies, and that's what we sell. But Good Shepherd's trying to claim the same thing. Yeah, okay, well. Anyways, that's a lot of what they're saying about the whole thing, so we don't have to go line by line through this entire response, but that's sort of where things are going, at least for the moment. So this lawsuit, at least for the moment, is skewing a little bit more in favor of the Isim Church Ministries, mostly because Mr. July is opening his face hole. So that should come as no surprise to anybody. All right. Let's cover another one. This was pretty interesting, for sure. The killer of Natalie Holloway has confessed to killing Natalie Holloway in open court in the United States. This has been his conviction, at least to me, always felt very tenuous. But he has come forward and said, I did it. So that helps resolve the tension real fast. I did the thing, helps resolve the question about, did you do the thing? The confession goes a long way, amazingly enough, right? So we're going to cover this a little bit. Spend a little bit of time on this. So you may remember this. This is from a couple years ago at this point. Jordan Vandersloot is the guy's name, has now confessed to killing Natalie Holloway with the cinder block and leaving her in the ocean. So that is something that happened. This is part of a plea deal in the United States related to extortion and related crimes like wire fraud and stuff like this. So the murder itself occurred overseas, so the United States wouldn't have jurisdiction for that, but it does have jurisdiction for the crimes that occurred in the United States, namely the extortion. So that is what happened there. So 2 decades after Natalie Holloway vanished in Aruba, the man had long been suspected has confessed to the killing. But it remains unclear whether he will ever serve time because Aruba apparently has a statute of limitations for homicide. Which, okay. I mean, that seems really odd to me, but okay. So we can't prosecute him for murder because it happened too long ago. Okay. Notably for our purposes, he was convicted relating to extortion for trying to extort the mom for about $250,000 for the location of the body, which is pretty bold, by the way. I killed your daughter and now pay me to tell you where her body is. I mean, that's a plan, I guess. Not necessarily a great plan, but a plan. The plea deal appears to benefit both sides. Vandersloot had been sentenced for 20 years for financial crimes, which will run simultaneously with an ongoing prison sentence in Peru, where the killer is convicted of killing another woman and trafficking cocaine. So Aruba never got to him for the murder of Natalie Holloway, and maybe never will, because for some reason, Aruba has a statute of limitations on murder. I know, but apparently they do. What do you want from me? I didn't come up with it. But he killed someone else in a different country. So he's serving time for that murder in Peru. And this sentence will run alongside that sentence. So he will never see the inside of an American prison. So that kind of sucks, I suppose. But I suppose it's good for the family because they finally got perhaps the closure that they wanted and the confession. So I guess that's nice. So, of course, the United States doesn't have jurisdiction over the homicide because that occurred in Aruba. But now the parents at least have some peace about, what happened. So, yeah. So apparently there was a proffer. We don't have the complete proffer, I don't think, but we do have some of his confession. So this was filed in court, and this is an interview that occurred between him and his own attorney, which was released as part of the plea deal. Obviously, privileged, but the privilege, of course, evaporates, if you want it. So they negotiated for this to be released as part of the whole plea. So this is a transcript of an interview between Jordan Vandersloot and his attorney who is doing this interview. So this is on tape that was conducted at some portion for whatever reason. And here is what they discussed. Vandersloot says, plus, she has to go back to her hotel, but I was just trying to get dropped off a little bit further away from the hotel so we could walk back to her hotel and I might still get a chance to be with her. The attorney, okay. Vandersloot, that's what I was hoping for. The attorney, okay, so what happens? Vandersloot, yeah, and Deepak drops me off at another place, a little right of the Marriott Hotel, known as the Fisherman Huts. This place is not so far from, the next hotel is the Marriott, and the next hotel after that is another Marriott, which is a timeshare. And then there is the Holiday Inn. We walk along the beach. The attorney. All right, do Deepak and Satosh get out? Come with. What happens? Vandersloot. No, Deepak and Satish leave. They leave. They go back to their home. I'm assuming they go back to their home. They get in their car and they leave. I'm actually with Natalee, walking along the beach. I find a space before we get to the Marriott Hotel where I lay her down. We lay down together in the sand and we start kissing each other. I get her to kiss me again and we start kissing each other. And I start feeling her up again and she tells me no. She tells me she doesn't want me to feel her up. I insist. I keep feeling her up either way. And she knees me, and she ends up kneeing me in the crotch. When she knees me in the crotch, I get up on the beach and I kick her extremely hard in the face. Yeah, she's laying down on an unconscious, possibly even dead, but definitely unconscious. And I see right next to her, there's a huge cinder block laying on the beach. The attorney block. When you say cinder block, I'm looking at walls at this place. Is it like those? Vandersloot. Exact same cinder blocks. I see a huge cinder block laying on the beach. I take this and yeah, I smash her head in with it completely. Yeah, her face basically, collapses in. Even though it's dark, I can see her face collapsed in. Afterward, I don't know exactly what to do. I'm scared. I don't know what to do. I decide to take her and put her in the ocean. So I grab her and I half pull and half walk with her into the ocean. I push her off. I walk up to about my knees into the ocean, and I push her off into the sea. Yeah. After that, I get out. I walk home. Well, that covers that up. That covers that pretty well. So, damn. So, apparently, he was scorned by his would-be romantic interest, and he was trying to feel her up, and so she kicked him in the crotch, and then he kicked her in the face, and then he crushed her face in with a cinder block, and then threw her in the ocean. So apparently that's what happened. So that's good, I suppose, to cover that story. And anyways, here is the actual plea agreement that he reached into between Vandersloot and the United States of America. So he was sentenced to 20 years for this to run concurrent with his sentence he's already serving. So he pled guilty to extortion, wire fraud, extortion and wire fraud. So here's apparently where the United States interest comes into play. So on top of the murder, here's what else he did. From 2005 to 2010, Vandersloot was a citizen of the Netherlands residing in Aruba. During a May 2005 high school graduation trip to Aruba, the Alabama native Natalie Holloway disappeared while in defendant Vandersloot's company. Natalie Holloway's location and circumstances surrounding her death have been unknown to her family, friends, and law enforcement since 2005. In March 2010, defendant Vandersloot contacted John Kelly, an attorney for Natalie Holloway's mother. Okay, so Vandersloot contacts an attorney for the mom. Great. Via email, seeking $250,000 in exchange for the location of Natalie Holloway's remains and information regarding her death. I mean, wow. That's just a bold move right there. I mean, on some level, I kind of admire the cojones of it, just because, like, wow. That is just an extra oofa special, right? I mean, I kill the girl, smash her face in, and then I say to myself, you know what would be a really good idea? Let me extort the mom for $250,000 about what happened to her daughter. Wow. I'm beginning to get the sense that Vandersloot may not be the nicest person. I'm just getting some subtle hints here, guys. I mean, I'm just trying to like run this through my own moral filter. And it's just amazing. Right? I think we can all sort of understand on some level, although, we would hope that our better angels would get us, and save us. But I suppose we can all sort of imagine like that raw rage that might cause us to do something that's super duper violent. But to make that very deliberate decision, that thoughtful decision to then extort the mom is a whole nother level. That requires a lot of conscious intent. That requires, thinking that through. He contacted the woman's attorney, for God's sake. So he had to think it through, type the emails, hit send. I mean, I'm just saying, it's a lot. I'm just saying, that's a lot. Wow. Kimby says, don't admire the boldness of demons. I don't know, man. I don't know. It's something. I don't think I would do that. I don't think I would extort the mother. I think I still have a soul left. I don't know. It strikes me as a lot. Anywho, he decided to send a note to the attorney asking for $250,000. The attorney that he contacted often served as an intermediary for the mom. Anxious to obtain information, they discussed the transaction. During April and May, defendant Vandersloot and Kelly exchanged numerous emails regarding the defendant Vandersloot's request for $250,000, how the information regarding Natalie Holloway's remains would be provided, and details of Kelly's travel to Aruba to meet with defendant Vandersloot to conduct the transaction. At one point, Kelly asked the defendant, Vandersloot, what would happen if Miss Holloway failed to provide the money to Vandersloot. Vandersloot apparently replied that Miss Holloway could wait another 5 years, causing Miss Holloway to believe that she might not actually know what became of her daughter. To complete the transaction, Vandersloot provided his bank account information in the Netherlands to Kelly. To confirm the legitimacy of the account, Holloway sent a wire transfer of $100 to the account. They confirmed the accounts had been deposited via the transaction. Kelly and defendant Vandersloot agreed that Kelly would travel to Aruba to provide an initial down payment of $25,000 to the defendant in furtherance of the demand. Ms. Holloway and defendant executed a written agreement. They have a contract now. How fun. We're reducing this to contract form. How exciting. For very obvious reasons, I don't think you're going to find a lot of judges who are going to uphold this contract. If you needed something beyond the extortion, we have this principle in law called unconscionability, right? The contract is, of course, a legal agreement, all right. And amazingly enough, there are some contracts the law will just flat out refuse to recognize, right? If we run out of all other reasons, we have this nice thing in reserve called unconscionability. It's like, yeah, we're just not going to do that. We are not going to recognize your contract. Your contract sucks. So yeah, this strikes me as what we would call an unconscionable contract. So first of all, it's illegal because it's extortion, and since it's a contract for an illegal thing, it's void. But if we needed a reason beyond that, unconscionability will work just fine. Wow. Yeah. The agreement further provided that after the remains were secured and confirmed, Holloway provided the remaining $225,000 via transfer. On May the 10th of 2010, Kelly and defendant Vandersloot met in Aruba at the Marriott Resort. Kelly provided $10,000 cash to Vandersloot, and following payments, Holloway initiated a wire transfer of $15,000 to the account. Vandersloot then reported to Kelly details surrounding the death and accompanied Kelly to a specific location in Aruba, where he reported that Natalie Holloway's remains were located. However, as defendant Vandersloot knew, both the details of her death and location of her remains were false. So he gave her bad information on top of everything else. So if we need yet another reason to void this contract, lack of consideration. So if you as long as we're trying to learn something of legal value over here, we can also ignore this contract. First of all, for it's an illegal thing because it's extortion, so it's void. If we want to get past that, how about it's unconscionable? If you want to get past that, how about there's no consideration? In order for a contract to be valid, both parties have to give something to the other that's of value. That's consideration, right? I give you money, you give me whatever it is I'm buying that day, right? I give you money, you give me food. I give you money, you give me a car. I give you money, you give me, a shirt. Whatever it is. Or it doesn't have to be money, right? We could exchange thing for thing. I give you video, you give me super chat. Sorry. No, I just say it. But it doesn't have to be money, right? It could be thing for thing. But here he's not giving something that has value because the information's false. So if we needed yet another reason to not recognize this contract, there's no consideration on his side of the agreement because what he's giving isn't real. So the contract is illusory. Ooh. See, you didn't realize you'd get this much legal analysis out of this thing, did you? But you're learning things. I know you are. You can't stop it. All right. Despite the fact Vandersloot retained the money, despite the fact that he didn't give anything. So, yeah. Following the meeting with Vandersloot, Miss Holloway, with the assistance of special agents from the FBI, worked to confirm Natalie Holloway's remains were not located at the place identified. Defendant Vandersloot had reported to Kelly that the body was placed under the foundation of a building near the Aruba Racket Club that was under construction at the time. So he said, I buried her in the foundation of a building. Which, could be. I mean, the mafia has allegedly done that from time to time. Authorities reviewed satellite imagery and information from the building inspectors in Aruba for specific lots where they reported they'd been buried. Authorities also interviewed owners of the lots regarding the timing of their lot purchases and construction. Based on the information, they confirmed there were no buildings under construction at the time. So the information was worthless. And there we see his signature on the document confirming all this to be true. So he might have done the extortion, right? He did the extortion because give me something or else. And then he did the wire fraud by having money transferred to him for lies. So yeah, he did those things. So that's the United States' interest in this equation. And so they stipulate that he gets 240 months, which is 20 years, with credit for time served to be run concurrently, which is at the same time, with the sentence in Peru, where he's currently serving 40 years, I believe, if memory serves correctly. So he will never see the inside of a US prison, but and also we want the $25,100 back. Because he kept the money. Right? We want the $25,100 back. We want the $100 from the verification of the $25,000 we gave you. So give us the money back. And so yeah. And yeah. So blah 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 blah. Yeah, they agree to cooperate, and the agreement is in exchange for cooperation. There's some waivers. Blah 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 blah. Sentencing guidelines. Agreement is binding on the court. So this is the type of plea that, once accepted, is binding on the court. There's special rules for that in the federal procedure. So there are special rules that require the court to accept the plea with its terms. So the court can refuse the plea, but if they accept the plea, they have to accept these terms. And there's other conditions in there and other jurisdiction. Of course, it does not bind any other state or local authority that might have any quarrel with him for the things that he did. Although I doubt there will be anything there. And we agree to admit all the crimes. Tax forfeiture, we would like the tax money for it. That's funny. So we're going to get our taxes too. We still want you to pay taxes. That's cute. I like that. The IRS wants to get paid. Restitution language, immigration status, acknowledgement, blah, 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 and all that good stuff. So that's the end of all that. So that's the end of the Natalie Holloway story. So he did it. He crushed her skull in with a cinder block and threw her into the ocean because she wouldn't let him feel her up. And then, perhaps even worse, although I'll let you guys decide amongst yourself which is worse, but I think it might be worse because it just requires that extra element of actually thinking things through. It requires that extra element of intention and deliberation, right? I think it might actually be worse in some ways. He extorts the mom. Give me money to learn the location of your daughter. And then he doesn't tell her. Yeah. He's not a U.S. citizen, so how is he taxable in the U.S.? I don't. Well, it would depend on, I suppose, where the money is earned in some sense. So I don't know. I don't know tax law that well, so I'll take a pass. But if you determine that for the purposes of, it would determine where the transaction occurred, I suppose, in the legal sense, where it occurred. And so you could make an arguable case that the transaction occurred in the United States. I mean, the extortion occurred in the United States because you're extorting a woman in the United States, and the agreement is in the United States, right? So you're agreeing with her. You're agreeing with her to payment, and that agreement is arguably occurring in the United States. So the income might be taxable in the United States because the income might be earned within the United States. And the United States has every right to tax you on illegal things. So that's how he might be taxable. So I'll let the tax lawyers figure that out about that, but it's possible. It's possible. He's going to get busted by the IRS for not filling out his tax return on time. Peru won't back up the U.S. decision. There's nothing for Peru to back up or not. The U.S. isn't asking anything from Peru. The U.S. isn't asking anything from Peru. So I'm not sure why you think Peru is into this. I mean, in so much as the tax money, but if it's tax money, that it would come from him anyway. Peru has no interest in this. So they're not asking him to be released to the United States. So I'm not sure why you say Peru won't back him up. They're not asking for Peru to back him up. The U.S. isn't seeking extradition. And even if they did, you're absolutely right. They wouldn't extradite him anyway. Peru has every legitimate interest to keep him too. So Peru won't back him up. I suppose it just doesn't matter very much. Thank you for the PayPal donation. $10. Thank you very much. I am happy to report that my sibling and their spouse and my new niece are now home from the hospital. That is good news. Excellent. I'm an uncle now. Ugh. It's like I wasn't 2 days ago, but now I am. Yeah. I liked my message on the community tab. It's like happy birthday to my niece who celebrates their 0th birthday today. I thought that was pretty cute. The world changes, my friend. The world changes. Let's cover something else. Okay. I want to go over this one. I've been delaying this one, and it's definitely time. All right. All right. So we're going to cover this case, which Rob covered on his channel, I believe, last week. I think I remember discussing it before. I seem to remember reading some of this. So I covered it either with Rob or Ian, or possibly both. I don't even remember at this point, because sometimes it all blends together. But we're going to definitely cover this too, because this is just way too hilarious. So this is the state of Oklahoma in the form of the Chief Justice of the Supreme Court versus Tracy Soderstrom, who is, at least for the moment, a judge. And the Supreme Court Chief Justice of the state of Oklahoma really doesn't think that Tracy over here deserves to be a judge anymore. They have some problems. So I have gone through, or more to the point, my editor, my mod did. Thank you, Tony, for helping. Tony went through this and highlighted some key portions of it, because where my compatriots in the law tube failed, and I will not, is by trying to read the whole thing from top to bottom. But there's just too much, right? And you get tired and you don't want to keep reading. So rather than trying to read the whole thing, we have highlighted for you portions that we will read to give you a amuse-bouche sense of what is going on. So what's going on? So we will read, hopefully, things that you have not heard before about this case, at least in part. Some of the things may be new. So we will see how that all goes. So we are covering this, and I still don't know what the hell the Court of the Judiciary of the state of Oklahoma is. What the hell is that? I don't know what that is. I really should look it up, but maybe another time. Anyways, all right. So we are seeking removal of office of this judge for violations of their job by gross neglect, gross partiality, oppression, and other grounds. And there's a whole bunch of things about the canons and the rules, which we will skip for the moment, because we just want to get to the facts about what's going on. All right. So we begin with this murder trial in June of 2023. Now, it is correct, I believe, this woman has only been on the bench since January, right? Of 2023. I believe it is on here somewhere. Yes. She took the seat. She took the seat for court on January the 9th of 2023. So she's not been at this very long. She's only been a judge since January of this year. And in June of this year, so 5 months later, 5 months later, she's hearing a murder trial. So she's, apparently hearing very serious matters right off the gate, which I think is also kind of notable. I guess it just strikes me as a little odd that 5 months in she's hearing a murder trial, but apparently that's where we are. Okay. Anyways, 5 months in she's hearing a murder trial. The judge exchanges over 500 text messages with her bailiff in which they mocked the physical appearance of the attorneys, judges, and witnesses, and used offensive language to deride the state's attorneys. The judge and the bailiff called the murder trial witnesses liars, admired the looks of police officers who were testifying, disparaged the local defense bar, expressed bias in favor of the defendant, and displayed partiality against the state. It's so much stuff. It's so much stuff. The judge and the bailiff texted back and forth with each other continuously during active portions of the murder trial when, they probably should have been listening to witnesses and stuff. Or, perhaps the bailiff should have been doing their bailiff thing by, looking around and making sure things were secure or whatever. But yeah, respondent apparently placed her personal cell phone towards the front of her lap outside the view of others in the courtroom. The judge was scrolling Facebook, accessing various phone applications, and texting for extended periods of time during the murder trial. Not that something else wasn't going on. The bailiff, who apparently was sitting in a witness box or small desk near the judge, sent and received text messages during the murder trial as well. On a separate occasion, the judge and the bailiff discussed by text which jury instructions would best fit their desired outcome. That seems odd to discuss that with the bailiff on every possible level. Not to put too fine a point on it, but the bailiff is, typically, it depends on your court, I guess, whether they're an executive or judicial officer. So we'll press past that for the moment. After publicly regarding the judge's excessive phone use during trial, the judge, or after publicity rather, so publicity came to the light that she was using her phone too much. The judge had a security camera moved so she couldn't be observed. When the camera was subsequently returned to its original location, a black box was inserted to block out the bottom half of the viewing area so the judge could not be seen. Fantastic. The pattern of conduct demonstrates gross neglect of duty, gross partiality, and oppression. Yeah, it's going that well. On June the 7th, the court took up upstanding issues before voir dire, in which we're going to, determine who should sit on this jury, but then brought in the jury and stated she would issue any remaining issues later. The ADA asked the evidentiary matters be settled before the jury was sworn, because once the jury is sworn, double jeopardy attaches, and the defense agreed, saying they'd like for motions to be argued and solved so they know what can be asked and be said. The judge said maybe they'd take it up that afternoon when they got to the point of swearing in the panel. Which, I sort of understand that part because the judge has to be in control of their courtroom. And it's like, if the judge is like, look, we're moving forward, this train's moving. I respect that to some degree, it's like we want to resolve. It's like if you're doing motions like right before trial, no, I can see a judge getting pissed off on that. So depending on the circumstance, like you come in with a last minute motion, I'm doing it later. Do it now because the jury was sworn in. I'm like, that's not my problem. This train moving, choo choo. So if that was what was going on, I'd be much more sympathetic to it, but I'm not sure that's what's happening. While defendant was addressing jurors during voir dire, the judge texted that he was sweating through his coat, to which the bailiff responded, yes, it's gross. He's gross and a horrible speaker. Regarding the assistant district attorney, the judge commented that they're going to hate him, referring to the jury as they. The bailiff responded, absolutely, he's an arrogant asshole. The bailiff then made a crass and demeaning reference to the prosecuting attorney's genitals, to which the judge responded with a ha-ha icon. Yeah. Conversely, when defense attorney addressed the jury during voir dire, the respondent remarked, she's awesome, to which the bailiff responded, yep, and she's so smart. During opening argument, the respondent continued to praise defense attorney by texting the bailiff, can I clap for her? Referencing the DA's office, respondent noticed they're not used to going up competent attorneys, implicitly dismissing the capabilities of the state's attorneys and the entire defense bar. When the DA began to question witnesses, the bailiff texted, he's horrible, to which the respondent responded, true. The bailiff replied, sucks. While a video was played to a witness on the stand, the respondent remarks to the bailiff, this shit is boring. I think the judge missed their calling, man. They must be better as a law tube commentator, right? This is like what we're highlighting, but so much whatever. DM says, what wasn't highlighted? Well, you do understand that if we highlighted everything, it would be the exact same as highlighting nothing, right? So we tried to highlight the things that we thought were most interesting, at least in our subjective judgment. Yeah. Later, respondent texted, state couldn't just accept that mom could kill their kid, so they went after the next person available, evincing her opinion about defendant's innocence. Respondent later texted, this is dumb, during the state's directed examination witnesses, and bailiff replied, I just hope the jury doesn't buy this shit. The respondent commented he looked constipated, and is that the oh shit look. Cute. The judge and bailiff referred to co-defendant, who has appeared as a witness, a liar at least 3 times on the stand. Respondent spent the majority of co-defendant's testimony on the phone, texting comments like, can I please scream liar, liar? Yeah, this is not exactly in the best keeping of a judge over here. When police officer took the stand, respondent texted, he's pretty, I could look at him all day, to which bailiff responded, same. The bailiff, respondent and bailiff also discussed whether the jury is wearing a wig, to which respondent texted, that's a wig, look at the hairline, and later she texted, definitely wearing a wig, to which bailiff responded, oh my God, LOL. This is pretty funny shit. This is pretty funny shit, for sure. Man. Okay. Nathan, the lawyer, said he can't make it because he has family stuff. So that's fine. Ian said he can't make it. He has family stuff. And Daddy on Direct said she can't make it because she said, I think she's in a deposition or something. Let's see. Oh, she's in mediation. So that's fine. Okay. It'll just be you guys, me tonight. That's fine. All right, so let's see. Okay, let's see. When a police officer took the stand, respondent texted, he's pretty, I could look at him all day, to which bailiff responded, same. The respondent and bailiff also texted whether the jury was wearing a wig, to which the judge responded, that's a wig, look at the hairline. And later said, definitely wearing a wig, to which the bailiff responded, oh my God, LOL. They wondered if another witness had teeth, and respondent texted, no, star witness right there. This is good shit. Later, the judge offered her opinion to the bailiff that DNA excluded Marzell on the bed. No way they get guilty on murder. During the trial, respondent approached Sergeant Kelly Coleman, captain and detective, in the hallway and stated co-defendant was not believable. She didn't think the defendant would be found guilty of murder, and he'd only be sentenced to credit for time served, which it's a little bit premature to be saying that, during the trial for obvious reasons. She granted defendant's request for additional instruction on manslaughter 2, which carried a sentence of 2 to 4 years. She took the state's request for murder 2 instruction, which is 85% crime, which means you have to serve 85% of the time before you're eligible for parole, under advisement. While discussing jury instructions with her bailiff, who was traveling apparently at the time, judge notified her that we're going to give alternative instruction of second-degree manslaughter. The bailiff responded, but no, just enabling child abuse. He didn't kill that kid. The judge answered no. Man 2 fits. Can't just do enabling because there's a dead person. Bailiff responded, so basically mom taking the plea deal screw him over. Respondent reassured the bailiff, no, man 2 is 2 to 4. Enabling is 255 to life. I'd rather give the man 2 instruction. The bailiff responded, he's already served that, to which the judge said, yep. Later that day, respondent denied state's request for murder 2 on the basis the request was made without sufficient evidence or notice, but it seems like they did give enough notice. The state then requested enabling child abuse instruction instead, and defense objected because there was a dead body, arguing there was case law to support the objection. Defense ultimately withdrew the objection because the case law mentioned did not support their position, and the judge then allowed the enabling child abuse instruction. The jury found defendant guilty of second-degree murder, or second-degree manslaughter, rather, and then sentenced him to time served, a sentence only a judge can impose. Respondent accepted the verdict and imposed a sentence of 4 years, giving him credit to time served. At the trial, the sheriff deputy advised the district attorney the respondent was seen using their phone throughout trial. The district attorney then concluded the respondent frequently sustained objections for facts not evidence during closing arguments, because the judge had not in fact heard whether the facts are reasonable evidence therefrom because they were not paying attention. Yeah, so that's the problem, right? She wasn't paying attention, so she didn't hear where the facts were in evidence. So her rulings, therefore, were wrong because she wasn't paying attention. Not to say a judge can't make a mistake, but if you're not paying attention in the first place, it certainly doesn't help. So, yeah. After being aware that there was a 51-minute video snippet of the trial that had been publicly showing the judge's excessive amount of time on the phone, the camera was moved forward at respondent's request to exclude the desk from view. The move left a hole in the ceiling. The camera was later moved back to its original location. A black box was inserted to block out the bottom half of the viewing area, so the judge's desk could not be seen. The county commissioner then voted to remove any obstruction from the camera viewing area, reasoning that the judge was not the only judge using the courtroom, and other judges did not have a problem with the original placement. While on vacation, Judge Mueller received a phone call from a courthouse employee who told her that the judge in question, in this case, said either that judge couldn't be trusted or better watch their back in light of the commissioner's decision. What the hell? When the judge testified before the Council of Judicial Complaints about these matters, she said she was texting about things that probably could have waited. Instead of recognizing these communications should never be made at all. Judge took sentencing out of jury's hands by not giving the proper charge. Yeah, quite possibly. Yeah, that's quite possibly. Like, the judge's decisions aren't necessarily wrong. She's just making them for the wrong reason, or she's showing improper animus. Like, I don't know what the right ruling is here. Like, I don't know whether or not these things should be charged or not. The judge's rulings may very well withstand scrutiny in the naked abstract. But like many people, she opened her mouth. Right? That's the perpetual problem. Right? The actions by themselves may very well be justifiable, particularly from an appellate posture. Not that you could appeal anyway, because the person that would be appealing in this situation would be the state, and the state can't appeal, because what are they going to do? It's double jeopardy. So, but in principle, if they could appeal, right? Even if they could appeal, the judge gets so much discretion about what goes on in their courtroom. So it might not be reversible for a judge to not give a charge. It might be, but it might not be, right? So judges get a fair amount of latitude. And judges certainly get a lot of latitude over what witnesses can be called, in what order, what they can testify to, what they can't, how long the question can go on, and a whole bunch of things. And a lot of those decisions are within the discretion of the judge. So, if, somehow the state could magically appeal this, and they didn't have all these text messages and everything, the Court of Appeals may very well not do anything about it. The text messages go a long way. So, as always, her opening her big mouth is the problem, because it takes the potential universe of potentially good faith explanations and somewhat collapses them. The good faith explanations are no longer as viable as they were when we started the day. The respondent also attempted to mislead the counsel regarding timing of the text messages, saying most of them occurred when a witness would come off or on when there was a pause, but not so much as it revealed. Then, what I think might even be worse, just because it is so weird, and it is not it's just strikes me as so off. The pink chairs, man, the pink chairs rubs me very much the wrong way. So like what happened in the murder trial is bad, but somehow, at least to my mind, this is arguably worse. I think it is worse, but you guys can decide for yourselves. In January, when she just took office, so she's a brand new baby judge, she's been there less than a month, the judge told a courthouse employee she was going to have men photographed in the hot pink chairs in her chambers, and her bailiff was going to hang the photographs on her wall. Okay. Yeah. So she's been a judge less than a month, and she says, you know what, my walls are looking a little bit plain. I'd like to have male attorneys sit down in my chairs in my chamber, which happen to be hot pink apparently. And I'd like to take photos of them and put them on my wall. Dude, I'm thinking we should check this woman's computer to see what other kinds of images she has. Cause this is pretty freaky shit, man. Yeah. So apparently, the Council of Judicial Complaints received allegations that male attorneys were being asked to pose for pictures in these pink chairs, and pictures were in fact displayed in the judge's outer chambers. There were no pictures of women in the chair. Some of the men felt uncomfortable, but didn't feel like they could refuse. Yeah. I feel like we need to check her computer for images. She sounds like she might be a prurient offender. Because this is so weird. After receiving the council's inquiry, the judge denied that any of the attorneys were forced to have their picture taken. And then, in my personal favorite thing that wasn't actually highlighted, but that's okay. She said there were photographs of both male and female attorneys hanging in the office, but those photographs were taken the day the judge received the complaint. The bailiff stated the judge got the complaint. I called her office saying that Tracy needed them. I took the pictures without the judge knowing, trying to protect the judge because the pink chairs were my fault. I'm not sure that makes me feel that much better, by the way. The bailiff says, yeah, I had the pictures so that I could look at the male attorneys in their suits and stuff. Dude. Yeah. When the judge entered her chamber and told her about the complaint, which says it's alleged that you have required male but not female attorneys to pose for pictures, none of the women mentioned they had just taken their pictures like then, just then, in the pink chairs. The judge says they didn't know pictures were being taken that day. The judge testified when she turned over pictures of the female attorneys in the pink chair, she thought they were already hanging. Yeah. Despite testifying to counsel, the false statements and evidence she submitted were attributable to the bailiff. The judge has not terminated the bailiff as an employee for not only allegedly lying to her, but causing her to submit false evidence to the investigative body. Which, you know, would definitely get my attention. You know, I join Ian on this. You know, if I have just made a representation to the court as an officer of the court, and I relied on you, like my employee or something, and I find out that you just got me to like tell a lie to the judge, yeah, we're gonna have words. They're not gonna be pleasant words. There's gonna be a lot of screaming. There's gonna be a lot of me having to like, you know, bow real low before the judge, begging for forgiveness. Yeah. So yeah, if I make a mistake to a judge, I'm definitely going to correct that. If the mistake is because you knowingly lied to me and I relied on you and you made me lie, not for nothing, but as I'm sure you can appreciate, a lawyer's reputation somewhat is important, and legal communities tend to be fairly small, especially as they relate to particular practice areas in particular places. So once you're down to like a particular practice area and you're in like a particular courtroom, there's not that many attorneys who are floating around. There might be a lot of attorneys doing a lot of different things, but they don't cross paths because they're doing a lot of different things. Like the bar for anything, the attorney's bar tends to be a fairly insular crowd, all things considered. And your reputation obviously matters a lot. And if you're caught lying before a judge, dude, that's going to be a real problem. So, I'm going to be kind of pissed. So then we had a hearing in which a woman was going to be a witness against somebody. The woman was the girlfriend of the defendant, and the judge said to the woman, who, mind you, is a witness at the time, Miss Argo, I don't know how long you and the defendant have been dating, but you might want to reconsider your life choices. Not that she's wrong, incidentally. She really should, but she's a witness that is going to be testifying. So if she had said it like after the testimony was over, that would be different. But to a pending witness, kind of a problem. In a different case, a defendant agreed to enter a plea of not guilty by reason of mental illness. The judge signed a journal entry finding defendant not guilty by reason of mental illness. The journal entry or the parties would appear back within 45 days for a hearing to ascertain whether there was a need for continuing supervision. The parties were already present. So, the judge indicated to others following the hearing the state lied to her in the presentation of the case because she didn't understand when signing the journal entry, the defendant would not be punished. She thought she was sending the defendant to a forensic center to determine whether he could stand trial. So you didn't understand. You didn't understand when you put in a journal entry said the defendant is not guilty, what that meant. You thought you were sending the defendant to a forensic center, having just entered an entry of not guilty. Great. That's great. The judge had a policy that plea paperwork must be completed with a copy delivered to her chambers no later than Friday before Tuesday deposition. Respondent said to the judge that the DAs, they've given me a reason in the past not to trust them, which you don't say that out loud, by the way. If you want to have the plea paperwork in a certain time frame, again, judges get a lot of control, right? It's so I want the plea agreement in hand at least 3 days before we enter it. Okay. I mean, that's just the way I roll. I want to take my time and make sure that I look it over or whatever. Okay, I won't do this last minute plea shit. I want it actually submitted in writing in advance. You can do that. But, when you're saying it's because I don't trust the DAs, when you say that, you're showing bias. In a different case that was set before the judge for an agreed plea on a motion to revoke for violation of a protective order, the judge contacted defense counsel asking that he and prosecution appear at prior to the plea hearing and discuss issues with the case. Okay. At the meeting, the judge told the attorneys they couldn't accept the plea because she reviewed the underlying protective order and didn't believe it was still in effect, even though it had been ordered to remain in effect in a companion domestic matter. When asked whether she was advocating for one side or engaging in an independent investigation when she obtained information about the order, she testified that she couldn't rely on defense counsel to have researched that on their behalf of their client because defense counsel was Zach Privet, who the judge had explained to the counsel she believed was incompetent. How did she become a judge in the first place? She was elected. How was she elected? I don't know. During a different trial, judge mocked the state in a text message to the bail saying they're not used to going up against competent attorneys. When asked who the attorneys were appearing opposite the state who were not competent, the judge responded, there are a number of attorneys that appear in my courtroom. They are not the level I practice at, not as prepared as when I go to trial, not having exhibit and type of things like that. My personal opinion is they're sloppy or lazy. As an example, our OIDS attorney very rarely, if ever, files any kind of motion on any issue. And one attorney in particular who I have great fondness for is very rarely prepared, Zach Privet. Which, not for nothing, but different attorneys have different styles in terms of how they like to do things. And those choices may particularly be valid. Like, I never personally was a huge fan of motion practice because I like to try to get, move the ball along. So I don't want to get slogged down in motion practice, but different attorneys think about it completely different. Some attorneys love motion practice. They just want papers flying back and forth in court. It drives me a little bit nuts, personally. So different attorneys might have a different sense of how to go about things, and certain things they do or do not care about. So a way they like to do business. And there's not necessarily anything wrong with those choices. There's different ways. Although you probably need to file them sometimes, which I'm not saying I would never file one, but I'm definitely not, motion practice heavy. Is sort of how I like things. But, if that's that attorney's style, it isn't necessarily wrong, but she's just demeaning other attorneys, you know what I mean? All right. So apparently at one trial, this is fun. Stephen Roberts' case. Stephen Roberts is on trial for first-degree murder for a shooting death of a rival motorcycle club member. All right. So we've got two biker gangs apparently in some sort of conflict. Okay. All right. So there was a hearing. There were a whole bunch of hearings that were docketed, stand your ground motion, bond, state's notice of intent to use gang evidence, and a whole bunch of things that were pending. All right. So there was apparently the trial is now underway, or there's a hearing, or there's a trial about the way. There's a trial underway, and then she's criticizing about whether the mother, who was a co-defendant in the trial, was blinking as much as the wife in a different trial. So apparently, many of the defendant's friends, families, and supporters were in the courtroom that day because the trial is underway at this point. So apparently, the defendant has many supporters in the audience, as you might expect. And the judge says this, apparently. But he's also in a biker gang that apparently likes to do some really ridiculous things that grown-ups shouldn't be doing. So that's a strike against him. But he's a member of a gang, and that's a negative. I find the notion of motorcycle gangs endanger the community in this kind of day and age to be ludicrous. I'm talking to anyone in the audience that may be one of those gangs. Be adults. This is ridiculous. Who here is a member of the outlaw motorcycle gang? I have a very good memory. If you come to court and testify, and testimony comes out you're a member of an outlaw motorcycle gang or the pagan motorcycle gang, and you sat in my courtroom and you didn't raise your hand, we're going to have a big problem. I'm remembering your faces. Yeah, just ask them to out themselves in open court. That's great. Respondent, the judge, apparently joined a Facebook group called Girl Attorney Oklahoma. In the group, in the group Girl Attorney Oklahoma, she published the following: note to future self, calling motorcycle gang stupid and juvenile in a room full of gang members may get you on a hit list. And later responded to her own post saying, one of these days, I'm going to learn to be judicial. I'm not so sure about that one. I'm not sure that you're going to be judicial one of these days. I'm sure about all that. That's yeah. I'm not having a lot of confidence in here. Apparently, at one point, someone contacted the judge's chambers to schedule an in-camera meeting. So, I'd like to appear before the judge alone, in her chambers. That's in camera chambers. I like to appear in chambers. Okay. To request to disqualify the judge pursuant to rule, which incidentally is probably the best way to go about this, right? If you want to, this is probably best practice. Like, you don't really want to do this in open court for so many obvious reasons. So it's like, I'd really like to have a meeting with you in chambers rather than do it in court, please. That's fine. It's a lot more polite. And again, judges have different styles. So some judges will do more in chambers and versus, in open court. It depends a lot on stylistic, and depends also on kind of on the culture. So it depends on the judge, and also kind of depends on the culture of the courthouse building in general, about what judges like to do things in chambers and what they don't. Some judges really don't like to do things in chambers. Some really do. So there's some stylistic in it there as well. In any event, he said, I'd like to meet with you in chambers to ask you to, not hear this case. The judge was out of the office, and the bailiff, for some reason, entering the equation, demanded to know why the attorney would be seeking the judge's disqualification before agreeing to call her to schedule a date for the in-camera request. Why the bailiff is asking this is beyond me, right? This is a question that you would think would come from the judge's clerk, assuming they have one. Because judges, clerks, again, depending on your judge and depending on the relationship with the clerk sometimes has quite a lot of power. And especially if the judge trusts them, and they will do a lot of things. And you don't want to piss off the clerk. Don't piss off the clerk is like, don't piss off the judge. And if you piss off the clerk, you're going to have a bad time. Okay. Anyways, for some reason, it's not the clerk asking this, it's the bailiff. After speaking with the judge, the bailiff called in the attorney and said, Judge wants names. She wants to know where he got the information. Was it from Rachel? Apparently referring to an assistant district attorney. The attorney confirmed that Rachel Thompson was one person who provided the information to him, but not the only person. The bailiff apparently said she wants all names. Okay, so we're doing our own inquisition over here with our own blacklist or something. That's exciting. Shortly after the attorney contacted the judge's chambers and she learned her post on the Girl Attorney Oklahoma Facebook page had been shared with him, the judge published a subsequent post that she was moving herself from the group because someone shared one of my posts outside the group. Apparently, this is not a safe place for a judge to be a human. Yeah. Yeah. The Facebook group, as it turns out, was not as super secret as she might have hoped, I guess. Prior to the in-camera request, the attorney advised the ADA he thought it was important to get the in-camera proceeding on the record. Okay, I want it on the record. And again, judges are different about this kind of thing. Like, it would not strike me as particularly odd that a judge wouldn't necessarily put things on the record in camera, because again, they would make notes about it after the fact. So they'd make a record of what happened, right? But there wouldn't be a transcript of it. There wouldn't be like a transcript with a court reporter, right? So sometimes you'll see that in like a movie, and it's not necessarily wrong, but sometimes courts aren't like that. There's not a court reporter for a in-camera meeting. There will be a record of it, especially if the judge issues any orders or anything, or there'll be like at least a minute order that says, kind of what happened. But again, they can be kind of informal. Judges have different styles about how they like to do things. So sometimes judges like it very much formal, and sometimes they like it informal. But you always sort of have the right to make it more formal, right? You have the right to make it more formal because you want to preserve your rights, which, fair enough. So it's like, okay, so the judge apparently is not normally of the course, it seems, of having a court reporter there. But they say, I want this on the record. I want a court reporter there. Okay. When the bailiff learned that the attorneys knew the judge was ready for them, they said to the bailiff, okay, we want a court reporter. The bailiff went to the judge and said the judge will not allow a court reporter in her chambers, which seems a little odd that you wouldn't want the judge in the in your chambers. They both said we want a court reporter, and they said no. Which, I suppose fair enough as far as it goes, but now there's only one alternative left, right? If you won't allow the court reporter into your chambers, which, okay, then there's only one attorney. There's only one option left. We have to go into court. We have to go into the courtroom. So we have to make this even more formal. Which, if that's the way you want it as a judge, I guess, but, it seems not necessarily the best course of action. After apparently both counsel entered chambers, the judge advised him that she previously called a judge who told her she's not required to put this on the record. The attorney responded, you might not be required to put it on the record, but we request that goes on the record. That means you're required to put it on the record. That's right. That's right. She's not necessarily required to put it on the record in the first instance. And some judges like that for a whole bunch of reasons that are very practical. Some judges want to play it a little bit more informal, a little bit more casual. That's cool. Judges have different styles. Get to know your judge a little bit, right? So after she refused, the attorney told the judge he wanted to go into the courtroom to make a record about it not being allowed to be on the record. The judge apparently said, "Are you serious?" rolling her eyes. When she affirmed, she said, "Okay, go into my courtroom." In her written response, the judge acknowledges that both parties were requesting a court reporter. So it's like, if you don't want this in chambers, I guess, but like, you shouldn't be like, oh, fine. It's like, it's just not exactly the most professional, right? It's like, you want to play it a little more casual. They want to play it a little bit more formal. Okay. Anyways. Apparently, during the judicial complaints conference, the judge was asked if she believed that one party was requesting a court reporter or both parties. The judge responded as follows. 1, at the time I originally said no. Miss Thompson was standing at my door, not my door, but the bailiff in the hallway. She's not yelling at me angrily, but she's away from me. She's like, we want a record. I'm like, you want a record? No, not in my chambers, not in my chambers. So you sought advice from other judges that before you were aware that both sides, because at one point you did become aware both sides wanted a court reporter. Is that accurate? Not until I went into the courthouse and made a record of it, but not a lawyer record. That's just funny. In written response to the counsel, the judge stated that she inquired of a different judge if she's required to allow the attorneys to have a court reporter during an in-chambers hearing. He advised no, he wouldn't do on the record and to keep it short, which sounds right as standard practice goes. Respondent again testified the judge told her that's not how it's working, it's not allowed. That part sounds wrong. The judge admits that respondent contacted about the issue but denies giving advice and further testifies he wouldn't give the advice because he doesn't believe it's in accordance with the law. And amazingly enough, that conversation is not on the record. All right. Apparently, there's a criminal bench book which states in part that refusal of a court to permit or require statements to be taken down and transcribed is a denial of due process. Fine. Yeah. So, yeah, if you want it on the record, we can do it on the record. If you want to do it in court, if you don't want it in your chambers, I guess we can do it in court, although it seems odd as shit. I'd rather do it, in closed chambers, but okay. But, yeah, in response to the arguments, The judge perceived an actual display of bias. The judge said, I'm human. I'm entitled to have an opinion of things. Every judge on the bench is entitled to have an opinion about how things go in the world. The judge went on to deny the in-camera request because she didn't believe the statement she made on Facebook met the standards for disqualification, including whether impartiality might be questioned, which has nothing to do with anything, by the way. You know, regardless of whether you believe that you should disqualify or have to disqualify yourself, that is separate and apart from whether it should be on the record. You know? So, like, you don't think you should recuse yourself? Fine, I guess. But they want it on the record that you don't want to recuse yourself. And so, yeah. So those two things are disconnected as thoughts. The attorney then filed a formal motion seeking disqualification. That hearing was then held on the record, which was denied. The judge testified she recognized her statements on Facebook about motorcycle gangs and hit lists was inappropriate before the in-camera hearing, yet still made the parties go through the hearing and refused to disqualify. Specifically, she testified, I agree today and agree on March 27th when the attorney called my office and saying they requesting I be recused. Yes, it's today I agree it's an inappropriate statement. And I agree back then too. I didn't recuse at that time because I felt again in court and the attorney had stated to me at all times that I was appropriate to him and his client, and I didn't feel like I was being biased. Yeah. Good times. In two other pending cases, counsels for defendants approached the judge in camera seeking recusal, as both those cases involved motorcycle gangs. On July 24th, 2023, respondent testified to the counsel, the parties had not met an in-camera request and parties don't really know all the specifics, specifically saying to the counsel, when they came in at this point in time, I didn't know anything about their case. I didn't know it involved motorcycle gangs or clubs. I didn't know anything about the case because it had been up on immunity. I hadn't reviewed it, was what I told him. I don't know anything about your case. I don't know anything about what they're charged with, what the facts are of the case, or anything about it. So let's hold the phone. And what I'm going to ask you to do, because I know you're not going to be on this jury term, let's put a pin in this and come back to it in the event you need to go forward with additional steps. We have plenty of time because I know I'm not going to be able to get you a hearing on request right now because I have these other cases that are set for jury time I need to deal with. And they were just there for status. I set another date and I said, talk to the Judge Turner, review transcripts, because both of those came in and said, we don't really know anything about those things. We don't have a motion filed or anything. We just heard. Dude, do you speak in sentences or what? This is so disorganized. And so I said, let's put a pin in this. We can take this up at another date when I know I'm going to have time. And so we just hadn't had the in-camera request other than a very, very quick judge. We don't really know the specifics. We're going to ask you to recuse, and so we haven't gone through the process yet. This is not the most well-organized series of thoughts I've ever read in my life. I have to admit. It's a little discombobbled. Okay. Apparently, the judge published on Facebook a blooper of the day. Wow. Defendant on a motion to revoke. I test positive for marijuana, but I have my card. Clueless judge. Is that even allowed? DA and defense counsel in unison. No, it's not. My bailiff, laughing hysterically. I need to read the marijuana laws. I am super encouraged. On March the 7th of 2023, respondent published to Facebook that she'd filled in for another judge and did my first domestic docket today. Finally, a subject I completely understand and can't possibly screw up. Not sure if everyone agreed, but I passed. Counsel interpreted this to mean that she thinks she screwed up in other cases. Which, Apparently, the judge posted on the Girl Attorney OK Facebook page what not to say to the judge. I've been doing this for 41 years and never done it that way. Definitely not a good idea, especially when you've been doing it wrong. Now, I'd like to take note here, okay? If you've been a judge for under 6 months and you have an attorney who says, I've been doing this 41 years and I've never done it that way, maybe that's the time to just take a step back and check yourself. Now, it could be the attorney has been doing it wrong for 41 years, but you might want to just take a second step there. Just a second thought of, let me just make sure. Apparently she didn't think that for some reason. So, that's good news. The judge issued a policy that all felony probable cause affidavits for warrants and arrests must be brought to her. Okay. The judge is otherwise the only district judge assigned to hear the felony criminal docket, and that could create a conflict if the same judge issues a probable cause affidavit and hears proceedings following the preliminary hearing. The judge asked the first assistant to discuss charges with her because she did not believe the charges were appropriate. The judge indicated to the attorney the charges were too harsh because the defendant was a juvenile when the charges were committed, and he's now an adult being charged as an adult. The respondent discussed the charges with Judge Mueller, who advised her she need only be concerned with whether probable cause exists because all her issues will be handled at the time of plea or preliminary hearing. That sounds about right. Respondent refused to sign or return probable cause affidavit to the state for 6 months. Wow. When the state inquired about it, she said she was going to confer with other judges about the issues. 6 months on a probable cause affidavit for a warrant? Dude. I've never heard of such a thing in my life. You'd be lucky for many courts if the judge takes 5 minutes before signing the damn thing. 6 months sitting on a probable cause affidavit for an arrest warrant? Holy shit. Dude. Shit. She doesn't say no. She doesn't say yes. She just sits on it. For 6 months. What were you waiting for, man? You want to talk to other judges about it? Okay. Did you not have some time before now to talk to another judge? Get a second opinion? Jesus. Yeah. I've never heard of such a thing in my life. All right. On the issue of hiring an attorney. During her second day on the bench, she said, it's generally the policy of the court that if you can afford to get out on bond, you can afford to hire an attorney. And I'm very hesitant to tax the taxpayers in this county in the judicial district where your representation costs because you're out on bond. You have a vehicle you do not drive because you can only drive one. What I'm going to do is order you sell the vehicle to try hire an attorney. I'm going to set you again on January 24th to appear. This is the third time. You have to reappear with an attorney. Do you understand that? At that time, if you do not have an attorney, we're going to revoke your bond. You'll be back in jail so you can qualify for indigent defense. Holy shit. In her written response, the judge, she's not going very well on day number 2, by the way. In her written response, the judge noted she was advised in 2022 Judicial College to be creative when dealing with defendants and their ability to pay. The reference to be creative at the college was from Judge Hetherington, relative to Rule 8 hearings, and the ability to pay for defendants whose fines and fees have been adjudicated, not defendants attempting to exercise their Sixth Amendment right to counsel. She further suggests next time she will suggest defendants sell an asset to hire an attorney, but not order it. Nice. The judge said, if you're out, you're capable of working and hiring an attorney. The judge added if she was out on bond, then she was capable of coming up with the money to get out of jail. Recognizing it was the judge's first month on the bench, the Council on Judicial Complaints sought a response from the judge about what perceived to be violation of the defendant's Sixth Amendment rights and violation of Oklahoma statute when the court determinations appointing defense counsel rely solely on whether the defendant was in custody or out of bond. The court anticipated the judge would recognize the explicit requirements of making determinations applications for court-appointed counsel based on citations provided by the counsel, and more specifically, the case law is clear that posting bond cannot be the sole factor in making the determination. So the counsel says, hey, judge, think you're making a mistake here. Here's some case law and citations. Since this is your first month on the bench and all, just want to let you know you seem to be making a mistake. So they sent her a memo. The judge instead, through her attorney apparently, responded the practice of not appointing counsel to litigant out on bond is not uncommon in many courts and courtrooms in the state. The judge's actions are no different than other judges in the state. Fun times. Fun times. During her first criminal jury trial, which included 2 felony acts, following the state's presentation of witnesses, the defense entered a blind plea. After the court accepted the plea, the defendant was escorted back to county jail, and her court-appointed counsel left the courtroom. Without opposing counsel or defendant present, the state and the judge continued to converse with the jury. The judge explained to the jury that entering a blind plea and what it meant. After asking the jury whether they had questions, the judge inquired, obviously we didn't hear the defense side of it, but show of hands, who's leaning towards guilty? At this point, sentencing had not yet occurred. So the jury is still sitting. The jury is still sitting, and she's talking to them without the presence of defense counsel. That's great. That's just great. After one juror apparently did not raise their hand, the judge inquired, Mr. Colson, you didn't raise your hand. After which the bailiff chimed in, I told you, he's the one I'm concerned about. The judge went on to advise the jury, so I'll tell you that there's a videotape in which she made statements consistent with the testimony of the daughter, to which the jury responded, that's what I was waiting on. Fantastic. She's telling the jury about evidence they haven't seen outside the presence of defense. It's going great, guys. It's going great. Following the ex-party conversation with the jury, the judge told Judge Mueller it was not a good idea for a defendant to blind plea to her and that she was going to throw the book at her. I'll look at everything, but it's not going to go well. At sentencing, which, by the way, this is ex-party. You might want to tell the defendant that, by the way. That might be critical information. At sentencing on April the 11th, the judge suggested to the defendant that exercising her constitutional right to a trial was an enhancing factor in the determination of the sentence. I shouldn't really need to explain this to anybody, but you can't give someone more time because they exercise their rights. Apparently, she says the following to the defendant, quote, we started the jury trial back in February and completed a day of testimony of a couple witnesses. And then on the second day, you decide to enter a blind plea. And you've pled guilty to the charges of lewd acts to a child under the age of 12, 2 counts, and of abuse, as stated in the amended information. You requested a preliminary hearing, which you required your daughter to testify in open court, in both your presence and that of the other perpetrator. You requested a jury trial, and then requested her daughter, your daughter, testify in open court and in your presence again, in the presence of 12 strangers and multiple individuals in the courtroom. And then after hearing the testimony for a second time, you decide to enter a plea of guilty. You have the right to a preliminary hearing. You have the right to a jury trial. You also have the obligation to protect your child. You required those two hearings, knowing you'd already confessed to the allegations not once, but twice. Yeah. If you have the right to a hearing, you have the right to the hearing. And yeah. So apparently he has the right to the hearing. So, okay. So she has problems with that, I guess, for some reason. Apparently, the attorney at some point learned that the judge had communicated with the jury, which was still sitting, by the way, and asked for permission to withdraw the guilty plea, which was denied. And that is just some of the things that have occurred. And we do not think that as a result, she should be a judge anymore. And that brings us to the end of that thing. So, yeah. That's a lot, man. That's a lot. That is a lot. That is a lot of things, man. That is a lot of things. Good times. All right. This is a short one. This is a short one because it's just that stupid. Okay. It's just stupid. It's one page, but it's just dumb. All right. So as I'm sure you are aware, Donald Trump was issued a gag order in relation to one of his cases. He insulted one of the clerks of the court, and the court got pissed, which I totally understand, by the way. Right? You start like, what does one of my clerks have to do with anything? It's like, if you want to say things about the judge, I guess you can. You really shouldn't, by the way. But like, yeah. So the judge said, you can't make statements about, my staff because they work for me. If you want to make statements publicly about how the court is doing X, Y, Z, basically I'm the buck stops here kind of idea, right? I'm the judge. These people work for me. They're doing what I asked them to do. So don't go after them, go after me. And also, by the way, that's probably a bad idea. But anyway, so the judge issued a gag order. Trump is appealing the gag order, which, fair enough. The man thinks he has a First Amendment right. He has a right to criticize the clerk or anyone else he wants. He wants to appeal the gag order. Okay. I understand this part. Here's the part I don't understand. Why his lawyers don't recognize that you have to be licensed to practice before the court. Here is a one-page memo. Here's a one-page memo from the United States Court of Appeals for the District of Columbia to John Laro. Dear Mr. Laro, it is my understanding you represent a party in the above captioned case. Our records reveal you're not a member of the bar of this court. He's not licensed to practice before the Court of Appeals. is the policy of this court that all attorneys appearing before it be members of the bar of this court. Our rules do not allow us to accept filings for attorneys who are not members. Also, the name of non-members may not appear on any opinion the court issues. Generally, attorneys must be members of the court to present oral argument. Unless you advise the court that you're not seeking admission and will not be representing a party, your completed application to become a member of this court is due November 2nd. The application and supporting documents may be electronically submitted with payments for fees through the case management system. Verily, truly yours, the clerk of court. And then they give them a copy of the application to be a lawyer before the Court of Appeals. That is some good shit. Now, personally, on a purely personal level, I think that my admission to the U.S. Supreme Court should automatically include all the federal courts, but it doesn't, which I think is a little bit bullshit. Because, okay, in both the case of Virginia and the case of Texas, I was sworn in by the court. Or it's, I was by law, right? And so when that happened, I instantly became licensed to practice in all courts in the state. Because, that's how that works, right? I'm licensed to so I think being licensed to practice before the U.S. Supreme Court should be the same thing. I think, I should be instantly licensed before all federal courts, but that's not how it works. First of all, I don't know that he's licensed before the U.S. Supreme Court, but even if he was, it wouldn't include all federal courts. Because the federal courts don't work that way, because I don't know, they just don't. I think it's a little bullshit, but they don't, right? You have to be individually licensed before each one of them. So that's 94 district courts, plus 13 courts of appeal, plus the U.S. Supreme Court. And you have to be licensed before every single one of them that you appear for, which may be a little bullshit, but it's the rule. I'm licensed before 2 of them. I got the Court of Appeals for the Federal Circuit, and I got the U.S. Supreme Court. So I got 2 out of, 94 plus 13 plus, it's 94 plus 14, right? So that's 108. Yeah, so I got 2 out of 108. Got to catch them all, Pokemon style. Yeah. I just think it's hilarious. So they aren't members of the court, so they got to ask nicely to be members. Yeah. I got a couple patents through work. I got a modest bonus. They said it was because of the cost of obtaining a patent. Is that expensive? The actual cost of obtaining the patent itself proper? No. The lawyers? Yes. It depends. Yeah. The actual cost to get a patent is not that expensive. I'd have to look up the fees again. It's been a while, but I think it's like less than, well, especially if you just, it depends how much you want to dick around with the office. So it depends on a lot of details. The actual fee to get a patent, if you file and it's accepted right out the gate, then it's not very expensive. If you want continuations, it adds up a little bit. The fees, however, that you will pay the patent office are nothing in comparison to the attorney's time, because the attorneys cost a fortune, because patent attorneys are fucking expensive. So it depends how much you want to dick around with the office, or how much you want, right? The problem, okay, let me describe the problem. All right. A patent is, we talk about claims in a patent. It's like a claim of land. It's the same idea, right? I stake my claim like a prospector, right? So you're going out into the wilderness and staking your claim. The wilderness being the invention in this case, because you've by your very aspect is I created something new. There's new land out there that I've created. It's brand new. I just created it just now. So the problem is you are entitled, of course, to as much new stuff as you have invented, but not more. So the problem from the point of view of the patent office and the attorneys that work with the patent office is trying to figure out exactly where the border is. And that can get really tricky and can take a lot of time and can be very frustrating. The patent office sort of anticipates this process is going to take 3 years. It's built into the patent. It's built into the Patent Act, because patents used to be 17 years from the date of filing, but now they're 20 years from the date of issue. So the patent office is sort of, and the United States Congress has sort of contemplated that we expect the process to get a patent is going to take 3 years. Now, it might not take that long. It will take less time the less ground that you try to cover. So the more that you want as much as you got, the longer it's likely to take. Because we have to figure out where those boundaries are, and that's where we get out the patent attorneys and the patent examiner, who are the surveyors in this equation. And then we go argue about where the boundaries are forever. So the more precision you want, the more expensive it's going to be. So there's your short answer to the question. In my 15 years, I think I had something like 2 or 3 that were granted right out the gate. It didn't happen very often. And there were more than a few that went through 3 or 4 or 5 rounds before either being accepted or abandoned because they ran out of money. So it depends. Yeah. Robin says, I agree my mission is Supreme Court should allow me parts from federal courts. I know, right? That's what I'm saying. You're admitted to 3 districts and 2 circuits. I know. That's what I'm saying. What is it? How does this bullshit work, Robin? How's this bullshit work? Why does my admission to the U.S. Supreme Court not grant me every federal court? My admission to the Supreme Court of Virginia grant me every court in Virginia. My admission to the Supreme Court of Texas grant me admission to every court in Texas. This is bullshit. My admission to the Supreme Court of the United States should give me admission to everyone. It's like, this is bullshit. Steve C says, makes total sense. Thanks for the explanation. Lunch on me. Thank you. Yeah. Another way I think about patenting is it's like an engineering problem. Like, how precise do you want your model to be? So if you want another way of thinking about your models, what level of accuracy do you need the model to be? If you want your model to be accurate to an inch versus a 10,000th of an inch, those are 2 very different price points. Yeah. So how accurate do you need your model to be? How precise do you need it to be? Do you need it to be just a fuzzy representation, or does it need to be perfect? Perfect is going to cost you a lot. It goes exponentially higher. It goes exponentially higher as you go through the orders of magnitude. It is not linear. It is very exponential. It's like they said in Breaking Bad when Gail Bierchek was talking to Frings, I can give you 96% accuracy, but Walter White can give you 99. And that might not sound like a lot, but it is. Yeah, it's kind of like that. It's do you need your patent to be 95% or do you need it to be 99.999%? Those are 2 very different numbers. Those are 2 very different numbers. So yeah. Yeah, the significant figures, man. Yeah, those significant figures are, that's the trick. That's the trick. So if you just want a patent for the sake of saying I have a patent, that's not too hard. It's actually really easy. If you, I told more than a few people this, and they laughed because they knew what I was saying. I was like, if you want a patent today, it's easy. I can do it like that. All you have to do is change one word in your claim, and I can do it today. All you have to do is change the word comprising to consisting essentially of. And all the patent attorneys in the room, which is probably me, but all the patent attorneys in the room know exactly what I'm talking about, right? It's like, yeah, all you have to do is change the word comprising and change it to consisting essentially of, and I guarantee you'll have a patent today. Those two words are very different words. They may sound similar. They're very, very different. Yeah. Okay, great. Moving on. I never had anyone take me up on the offer. As well, they shouldn't, because it would be really freaking dumb. It'd be really incredibly dumb. I was like, if you really want a patent, though, I can make it happen now. Do you want a patent that's worth anything? That's another story. Okay, great. Moving on. What does it do? Comprising is a non-exhaustive list. Consisting essentially of is an exhaustive list. So the difference is if I say this invention comprises A, B, and C, it has to have A, B, and C. But if it has more than that, that's fine. Because it comprises A, B, and C, right? It includes those things. So it has to include those things, but it can also include other things. Comprising means it must have those elements, but other elements are okay. Consisting of means those elements and nothing more. So overcoming the patent becomes trivial because all I have to do is add one more thing and it no longer reads on the claim. If I say consisting of A, B, and C, if I add D, it's no longer consisting of A, B, and C. It now consists of A, B, C, and D, and those are different things. So it's makes the patent instantly grantable because if you add anything to it, it no longer reads on the claim. It would be like me telling you a recipe. Like it's like, because patents are recipes. It'd be like me saying, okay, this cake batter consists of eggs, flour, and water versus comprises egg, flour, and water, right? Comprises egg, flour, and water means, yeah, you could add chocolate, you could add strawberry, you could add cream to it, you could add anything, right? As long as it has eggs, flour, and water, it comprises. If I say consists of eggs, flour, and water, you add one more thing to it, it's no longer the same thing. So it shrinks your invention down to nothing. Granted, but useless. Yeah, exactly. Which is why I can give you a patent today, because it's useless. I can give you a patent, it just won't mean anything. You'll have a registration number. It won't be worth anything, but you'll have it. It's like, yeah, I can get you a patent today, no problem. All you have to do is change this to this, no problem. You can have a patent today, no problem. It won't be worth anything, but you can have it. Anyways, so that is a very, very inside baseball joke. And I've now explained the extremely inside baseball joke. So you're now on the inside. So you can laugh along with the patent lawyers. How fun. Yeah. Yeah. So now you're on the inside. One of us. Gooble gobble, gooble gobble. All right. Let's see what else we got on the list today. Yeah, I think we might be wrapping this up. Yeah, 2.5 hours in, I'm ready for nap time. First of all, I need a shower. I haven't showered since the gym and I'm feeling very, very sticky. And I need a shower very badly. I am not fresh and clean. It's very sad for uncivil law, but it's true. All right. Let us read this story. Arkansas man is today's Florida man. Arkansas man was found by the police having sex with a stuffed animal in his rocking vehicle. If this van is a rocking, don't come a knocking. but the police did, and they found him having sex with a stuffed animal. Here is Theodore Morgavin, who is 55, who apparently was trying to get his freak on with Teddy Ruxpin, I guess. The 55-year-old Arkansas man is facing drug charges. Oh, drugs were involved, you say? Well, I couldn't have seen that one coming. Apparently facing drug and sexual indecency charges after a deputy apparently spotted him having sex with a stuffed animal. A judge has found probable cause to charge the 55-year-old with possession of a controlled substance, namely meth. Wow, what are the odds there? He was using meth at the time. Who could have possibly foreseen that? I mean, that sounds so unlikely. Meth. Wow, didn't see that one coming. Apparently, furnishing, possessing, or using prohibited articles, possession of drug paraphernalia, and sexual indecency. According to court documents, the Baxter County Sheriff's deputy saw a vehicle 1245 on last Sunday at a Midway store and Lock, a self-storage facility. The deputy apparently observed the vehicle rocking. The deputy looked inside the vehicle and saw the man having sex with a stuffed animal. Upon learning that he had a search waiver, of course he does. Upon learning that he has a search warrant waiver on file, as a result of prior interactions with the, amazingly enough, this is not his first interaction with the legal system. I know. So apparently he has a search warrant waiver on file. The deputy then searched the vehicle and found a purse containing 2 marijuana pipes and a syringe. While being booked, the affidavit stated another deputy found approximately 3 grams of meth in the purse. The judge set the bond at $5,000. Yeah. I don't really know what to say about all that, to be honest. That's a thing that happened. I have no comments. You never heard of a search warrant waiver? It means he's on probation. That's what that means. Yeah. It's what it means. He's on probation. It's a standard condition of probation, right? Because it's part of your original sentence. And so in the same way that, they can search your prison cell at any time because, prison, when you're out on probation or parole, they can search your shit at any time because you're in prison light. So, yeah, that's what that means. Yep, that's what that means. Robin says U.S. attorneys do not need to be admitted to states where they're working. That's true because they're working inside the federal system, which can be problematic when they're involved in civil actions, which include state law claims. That's fair. Yeah. But yeah, because the U.S. attorneys don't need to be, they're working within the federal system and they get to jump around from court to court. I don't know how that works in terms of being admitted to the federal court, but you're right. They don't need to be admitted within the state, which makes sense, incidentally, because it's the same way that I, as a patent attorney, don't need the permission of Virginia or Texas, for that matter, to practice my patent law trade because I have a federal license. So I can continue being a patent attorney anywhere. There was a case at the U.S. Supreme Court about it, in the 80s, I think, which clarified this, but, it makes sense, right? Because there was a guy who was admitted to practice patent law who opened up shop in Florida. He had a shingle out, as it were, a patent attorney at law. And the Florida bar got really pissy at him because he's like, you're not an attorney because you're not licensed to practice. And the Florida Supreme Court got really pissy at him. It's like, you're not an attorney. You're not licensed to practice. And the U.S. Supreme Court said, fuck you. He's licensed to practice federal law. He has a federal license. He doesn't need your permission to practice in your state because he's a federal license. So go fuck off. And so, yeah. So as a patent attorney, I can ply my trade anywhere. So I got that going for me. I don't need your permission to move to Montana or whatever and open and put out a sign that says patent attorney at law. I can do it anywhere. Fuck you. I have federal permission. Screw off. So, yeah. Fishby, what do you think about that story? Well, as a stuffed animal myself, I find the story very concerning. I'm a Fishby. I'm not made for such things. Yeah. Oh man, too funny. What else is going on? Sidney Powell pled guilty. We could watch her plea conference if you guys like. I'm getting tired though. But Sidney Powell pled guilty, perhaps unsurprisingly, in the Georgia case. So, yeah. So that's not surprising. The plea deal does specifically indicate, though, that it's not a crime of moral turpitude. So it's unclear whether or not her Texas law license will be impacted or not by her plea. But yeah, so that's fun. Alex Murdaugh won his motion to have his appeal withdrawn so that he can move for a new trial as he tries to push on for a new trial. I don't see how this doesn't end without a hearing, in which case jurors will be called to the stand. I mean, that's the only way this can end at this point, I think. Anything else seems wrong. I don't know what the end result of that hearing will be, but I don't see how this doesn't end in a hearing where we're calling jurors to the stand and asking them, so, hey, did the clerk, come up to you or coerce you or stuff? So we're going to prod into what the jury's deliberations were, which doesn't happen every day or like ever. But I guess that's what we're doing now. Robin the ADR Pro just became a member. Thank you, Robin the ADR Pro, for helping to support this channel financially. I really appreciate everyone who supports the channel financially. And thank you, Steve, earlier for the $20. I'm not going to lie. The money does help a lot because I'm increasing the expenses of this channel significantly to try to help provide you better quality content and hopefully content more people will like so the channel can succeed. So your donations really make a huge difference as I'm undergoing quite significant expense right now to produce content. Hopefully it works. But your money is going to good use at the moment. So that's nice. What else is going on? Florida is looking at holding a formal Florida Man Games, which is apparently a thing that's happening. That's pretty funny. Apparently, Florida Man is going formal. There's going to be a 2024 Florida Man Games that's going to come to St. Augustine. I need tickets. Thank you, Bree H, for becoming a member. All right. So apparently, there's going to be 16 teams of Florida men who will be competing in such games as weaponized pool noodle mud dueling, an evading arrest obstacle course, a Category 5 hurricane wind cash grab, and beer belly Florida sumo wrestling. And apparently, these are teams of 5 who will be competing in these games. Tickets are apparently $50 for general admission and $155 for VIP tickets, which include drinks, access to climate controlled VIP area, access to air conditioned bathrooms, and reserved bleacher seatings. I need $155, guys. Apparently, the events include weaponized pool noodle mud dueling, test your strength inside the Florida Man Games Coliseum, massive above ground pool, the evading arrest obstacle course, jump over fences through backyards and away from actual police officers to earn your freedom. Category 5 cash gab, subject yourself to Category 5 wins as you scramble to catch as much cash as you can. A catalytic converter, 2 bikes, and handful of copper pipes race against time. Compete head-to-head in a race that lets you live a day in the life of Florida Man headline. Beer belly Florida sumo. Dive right into the bigger belly of the beast as you try to blast your opponent out of the ring. There will also apparently be a mullet contest. Florida is well known for being the home of the most outrageous mullet cuts on the planet. Watch and pick winners of the mullet contest and Florida Ma'am pinup. Okay. There's also apparently a chicken coop bingo. 2 chickens will decide whether you win or lose in this fun, dirty game inspired by Floridian family in places like D-Land or Interlachen, where you literally do this for fun because we don't know cell phones exist. And 911 Fight Night, Brawl the Badges. Watch officers take on firefighters in the Brawl the Badges main event as Florida Man games come to a close. The epic showdown promises to be as intense as the heroes clash in a battle to prove who's the toughest behind the badge. I need $155, guys. I need $155. And yeah. I wonder if I can get press passes. I need press passes. That's what I need in my life. They did not mention gators, but that doesn't mean that there aren't gators. They just did not mention them in the article. Yeah, so I think that's enough for Thursday night Thunderdome. Or is Thursday Night Thunderdome a good name? Thursday Night Thunderdome's not bad. Thursday Night Legal Thunderdome. It does go with the alliteration for T. Maybe we'll rename it Thursday Night Thunderdome. We're still working on the title. Maybe we'll rename it Thursday Night Thunderdome next week. You guys got any suggestions for a name for the stream? Unclear whether you can bring an emotional support alligator. That is not clear in the story. Yeah. All right. Well, I guess that will end for our stream for tonight. So I appreciate those of you who decided to join me. Thursday Night Thunderdome could lead to some fun theme nails. That's true. Yeah, that's true. It could lead to some nice thumbnails. Yeah, Thursday Night Thunderdome. Because you got Friday Night Frenzy, right? And so Thursday Night Thunderdome does have the nice alliteration. There's no way they could get insurance for gators. Who says they have insurance for any of this other stuff? You think that they have insurance? That's high expectations. Yeah. The workout went very well today. Let me tell you what I did in my workout today. I will look at my log. Let us look at the log. The log tells us what we did. All right, today, first of all, we did 10 minutes and 30 seconds at level 6 resistance on the elliptical, traveling 1.05 miles. So we got in some cardio today. I'm going to try to put cardio every day that I work out. So I'm going to alternate between probably elliptical and seated bike. And also they have an arc machine, so I might do that too. And possibly as I get more in shape, some rowing, but that will have to wait because right now it would kill me. But I did do 10 minutes and 30 seconds at level 6 resistance going 1.05 miles on the elliptical machine. So that was nice. But then we did cable lateral raise. That's one hand raise where you just take your arm and you lift it straight up by your side. We did 4 sets of 10 reps at 30 pounds. Then we did a tricep extension where it's just where you take it up, you curl it up, and you flex it down to work your tricep. I did 10 reps at 20, 10 reps at 30, and 10 reps at 40. I did a stable standing cable core twist, 2 sets at 8 reps at 60 pounds, and then 1 at 50 pounds. Then I did cable row. It's where it's the seated row and you get the cable machine row. I did 4 sets of 8 reps at 160. And then I did machine bicep curl, 3 sets of 10 reps at 95 pounds. Total volume lifted today, 13,930 pounds. It says 554 calories burned. I'm not sure if I believe it, but that's what it says. And any progress is good progress. Any progress is good progress. So, yeah. Monday Night Madness, Thursday Night Thunderdome, Friday Night Frenzy. Yeah, I think that works. I think Thursday Night Thunderdome is better than even Extravaganza. Yeah, some solid curls. It was respectable curls, for sure. Yeah. Throwdown. Throwdown's not bad. Yeah, it's not bad. So, and then 2 days ago, or whatever it is now, I did my lower exercise. Yeah. So 2 days ago, I did cycling, 10 minutes at 6 resistance, 1.82 miles. Did machine squat. 10 reps, 220, 8 reps, 220, then 10 reps, 220. Did calf raise, machine calf raise, 3 sets, 10 reps at 130. Seated leg curl, 4 sets, 8 reps at 130. Seated back extension. I apparently am a beast at the seated back extension because I'm running out of machine. I'm running out of weight on the machine for seated back extension. Apparently, I am just the best at seated back extension ever. 4 sets, 10 reps, 280 pounds. Apparently, I'm an absolute beast on back extension, and I could go more. I know I can. The machine only goes to like 300, and I'm going to run out. I know I could do 300. So apparently, I'm an absolute beast when it comes to back extensions, I guess. on the back extension machine at least. Cable crunch, which in this one we have one that's a stand-up cable crunch. So you stand up and you have the things above you and you crunch down while standing up. 3 sets, 10 reps at 100 pounds. How's the shift to highly edited videos going so far? Not as well as I would like to, if I can be honest. The expense, there is considerable expense. There's considerable expense in the edited videos. So for it to be economically viable, I have to get enough views to make it viable. And we are nowhere close. We're nowhere close to it being economically viable. So we need a lot more. So I'm really hoping these videos will get like 50,000 views or 100,000 views. And we're not getting that right now. So that being said, we're just trying it. And we're trying 2 editors. And I'm now interviewing a third to see if maybe they have the secret to what I need. But we're trying things. You know. I forget what the it's about $10 per 1,000 views. I think I'd have to double check on the back end. So I need about, I need lots of views. Is it too late to watch them? No, it's not too late to watch them. You can watch them. I hope you do. I hope you enjoy it. You wish my face was in it? I'm experimenting. I'm experimenting with stuff that's going to be faceless, stuff that's just voiceover. I'm experimenting, see what works. Nate the lawyer has done faceless stuff to great effect, along with stuff that has a face in it. He mixes it up. I thought it was worth it trying. So we'll try stuff that's faceless or that has less face in it. Stuff to make the reading more interesting. We'll still have Thursday nights together. So I'm not planning on disappearing completely. But yeah, we need these videos to blow up in a huge way in order to make the economics viable. So we'll see. Sound a really cool documentary. I spent a lot of time on that, on the script. Spent a lot of time on it. And I spent a lot of time on the script for one that's coming out tomorrow too, about the Israeli conflict. I hope it works. We'll see. Huge part of my brand is my smirk expression. Yeah, maybe. I don't mind if you don't watch shorts. The shorts that exist are mostly just to promote the channel. At least that's the concept behind them. The shorts are meant just to drive people towards the main channel in the first place. So you don't have to watch shorts. It's fine. All right, I'm going to sign off for now, and we'll just keep experimenting and just keep growing. We gotta figure out how to make. We gotta really figure out how to make it work. You know, we gotta figure out how to bring in the kind of live viewers, for example, that my compatriots are getting. You know, we got to figure out how to make this channel have the kind of live viewers that my other friends in LawTube are getting. And I'd like to think that I'm worthy of it too. It's not that they're not worthy of their viewers, but I'd like to think I'm worthy of it. But right now we're underperforming on live viewers. We're underperforming on super chats compared to some of our friends. And so we need to figure out how to make it work. We need to figure out how to change the revenue structure of the channel so that we can afford to do more things. And I'm not always like scraping by, you know. Have we considered paid advertising? I'm not bringing enough views for paid advertising. I can't charge enough because I'm not bringing in the views in the first place. Paid advertisers pay by the views. That's how they typically pay. They pay for views. I'm not bringing enough views to attract a paid advertiser. What would they be paying for, right? There's not enough to attract them. So we need to change the economics. Oh, consider paying for my own advertising. I've done that before. I've I've paid for AdSense before. I've paid for things before. It tends to be too expensive. The ads tend to run about 2 cents a view, which winds up being uneconomical real fast. So but yes, I have experimented with paid advertising before. But if I spent $100, I would be buying probably something like probably something like 5,000 views, 6,000 views for $100. And it's more money than I'm getting back because I'm only getting about $10 a view, $10 per 1,000 back. So I'd be spending $100 to get back about $60. So is not economical in my experience. I've tried AdSense. I've tried the best success I've had is with third-party brokers. But I'm not sure I necessarily trust all their methods, to be honest. I want to make sure that we're doing everything in keeping with the policies. So yeah. Am I one to show for products that I know don't work? Possibly. But right now the economics are just not there. Last time I tried to pay for Twitter advertising, I got like basically nothing out of it. Yeah. So advertising has wound up in my experience not be economical. Yeah. Well, that's enough behind the scenes stuff. I'm going to sign off for now and I'm going to take a shower. So I hope you've all had a great night. I've had a great night. Until later, my friends, I've been Uncivil Law. Hope all is well. Cheers and goodbye.